Ms. Burns, would you please call the roll?
Good morning. Here. Burnell?
Here.
Here.
Booth?
Here.
Horn?
Here.
Jones?
Present.
And Phillips.
Here.
All in attendance, we have
Can I say something, please? My microphone, I don't keep holding it, it's not staying on. Okay.
Yes, you have to hold it down, and hopefully we'll be able to remedy that situation, because it's going to make it difficult. So, good morning and welcome to a meeting of the Board of Psychology. It's nice to see so many guests in attendance here, or members of the public in attendance. I wanted to talk a minute about what the mission of the Board of Psychology is. The mission of the Board of Psychology is to advance quality psychological services for Californians by ensuring ethical and legal practice and supporting the evolution of the profession. Our values are transparency, integrity, consumer protection, inclusiveness, excellence, and accountability. With that in mind, I would like to indicate for those of you that are tracking our schedule for today that there's going to be a little bit of change in the agenda. And this is the order that we'll be taking items. We're now on item number 2. We'll proceed to item number 3, 4, 5, then 7 and 8, because I know there are several members of the public that may want to comment on the subject of child custody evaluations. And then we'll be moving to the Policy and Advocacy Committee report. Hopefully we'll be able to complete that before we take lunch. We may take lunch a little on the later side today. And then after lunch, we're going to move to items number 6, 9, 10, and 11. And item number 13 will probably carry over to tomorrow, which will be recommendations from the Licensing Committee. At 3 p.m., we'll be having a petition hearing. It'll be the petition for early termination of probation. After that, the board will go into closed session for deliberations relating to enforcement matters. So there may be items that carry over into tomorrow. I didn't want anybody to be surprised about where they're coming up in the batting order, so to speak. But before we do anything else, we have a new board member joining us, Mr. Seiran Fu. He's a public member who was appointed by Governor Brown, and we're very much happy to have him here. He really brings our average age down considerably. I could lap him, literally, on age. But it'll be wonderful to work with him. He has quite a background in government and public policy. He currently works in the philanthropy area, but he has a master's degree in public policy from the Woodrow Wilson School at Princeton. So I think he'll be a great addition to our board, and we wanted to welcome you. And in light of that fact, we are now going to administer your oath. So please repeat after me. Okay. I, Seiran Fu, do solemnly swear or affirm that I will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, and that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California. That I take this obligation freely without any mental reservation or purpose of evasion. So we do have an action-packed agenda today. There are, I think, several members of the public that may want to make public comment later on. And in light of that fact, we'll have to be relatively fast-paced about the public comment in order to be able to complete our agenda in the 2 days, but we also want to give you some opportunity to comment. So well, it's going to be a balancing act. Item number 3 is public comments for items not on the agenda. I would remind the board members that they may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. So, and this is not where we'll be discussing the child custody evaluation question. Are there any public comments on items that are not on the agenda? Seeing, yeah? Do you want to come forward?
Mine are more general comments. I have comments for 1 and 8. These are more general comments. Is that I represent that now?
More general comments as to subject number 8, child custody evaluation?
It has linked to the overall board of the latest process.
Oh, certainly, feel free. You'll have to press the button as you speak the whole time. You have to hold it down.
Members of the board, thank you for hearing us today. My name is Catherine Campbell, and I am with the California Protective Parents Association, CPPA, a nonprofit with the goals of protecting children from abuse. Over the past 18 years, our association has worked with the Board of Psychology to help implement better practices and to bring awareness to the problems. CPPA has been in contact with the Board of Psychology with former Executive Director Robert Cahan, who stated that the Board of Psychology could only discipline or investigate those who breached their own code of ethics when it was brought to the board's attention regarding the problems of family court and evaluators or any other processes that have with the board. The Board of Psychology adheres to the APA's ethics, through which there are 5 general principles: beneficence, non-maleficence, fidelity and responsibility, integrity, justice, respect for people's rights and dignity. Each of these principles have been breached. By not fully investigating complaints for any psychologists, these breaches or hold people accountable, and they're not being disciplined. People are retaining their license and perpetrating harm to those that they serve, and they're in opposition of the general principles. This has not been prudent behavior by the board, and I will discuss more of this in line number 8. CPPA has also met with Mr. Cahan and Gina Bayless to encourage the board to adopt requirements, and we certainly know that some organizations have been hired, and it's through the courts that they have been hired, but we realize that these agencies are no longer being used, and we realize that with the courts having jurisdiction in appointing trainers, and regardless to Section Code 3110.5 and 3118, the agencies that are being appointed to train evaluators are not being trained properly for abuse cases. This goes against Senate Bill 1716, and that's from the year 2000, which amended some of these section codes to help keep children safe. And with this implementation of 1716, we have yet to see change. It hasn't been adhered to. And what we need to know is that the bottom line for psychologists who have in a system that would not be allowed in any court, we're allowing them to have behaviors that just allow them to continue mistreatment. Evaluators are handpicked by lawyers. Evaluators are dependent on continuing pleasing lawyers to ensure revenue flow. There is no cap on the cost of evaluations, and as stated, the evaluators are not properly being held accountable while having their recommendations rubber stamped by courts. Can you imagine a court system where a judge was handpicked by the lawyers versus drawn from a pool of judges, and judges could charge whatever the market would bear? We are allowing psychologists who do evaluations to be incentivized to go down the wrong path. If we are enabling evaluators to do their jobs, it's time we stop allowing them. to do this and get into this vicious loop. It's time we take in the reins and allow for accountability to protect our children, no matter whether it's in a court setting or in any setting for psychologists. Thank you.
Thank you very much. Is it a comment other than on child custody evaluation? Because, okay.
I am Mrs. Helen Lynn, Protect Our Kids. I'm a child activist, and I have been attending Sacramento legislation hearings on bills to protect children for 20 years. And this is what I want you on the California Psychology Board to know. Did you know opposing laws to protect children are the California Board of Psychology, the California Judges Association, the California Judicial Council, and the California State Bar Family Law Division? Thank you.
Thank you very much. Ma'am, you want to come forward? As long as it's not on child custody evaluation, because we will reach that later on.
Sure. Okay, thank you. This is related but a separate agenda item, or it's not an item on the agenda, so I did want to raise it for the board's consideration. My name is Kathleen Russell. I'm the Executive Director of the Center for Judicial Excellence, and we presented to you back in February in Sacramento. I want to thank you for your public comment session here, and also just raise an issue that I understand from a review of your rules and guidelines, that this board has the ability to issue a cease and desist order, which would be a way to expedite discipline of psychologists that does not involve the investigation of actual complaints in particular cases with psychologists. And so I am here to ask that you consider ordering a cease and desist on all reunification camps in California that are being run by licensed PhD psychologists. And for those who didn't see this, I brought a copy for your board to pass around. Washington Post magazine from May of 2017, where the California Board of Psychology is referenced because the case involved in this in-depth expose that was the focus of this article has been a pending complaint sitting with this board for over 2 years now. And these are also issues affecting the safety and future viability of children. I see that you're tracking a bill on ACEs and the Adverse Childhood Experiences Study. If this board does not take action to cease and desist all of these for-profit reunification camps, which are traumatizing teenagers like the ones in this article, then you are complicit in the abuse of these children. This is not abiding by the code of ethics or taking the mental health of these young people to heart when you are forcing children in for $8,000 a day to go to these camps with parents that they have PTSD as a result of abuse by. So I bring this to your attention. I ask you to please consider, or maybe at your next meeting, put on the agenda what is required or an explanation of how this board handles cease and desist orders. And just to give you a quick run through, Dr. Rebecca Bailey in Sonoma County, Dr. Deirdre Rand, and Dr. Randy Rand in Mill Valley are doing these camps. Dr. Jane Schatz.
Excuse me, we can't talk about specific names of licensees because if there were a complaint against them that came before the board, we would be prejudiced by your comments, which would
I thought that was only specific to a case. These are people harming multiple children, and I'm not a complainant in a case?
I would prefer that we not use the names of specific
Okay.
licensees so that we preserve the ability to be able to fairly adjudicate those claims.
Understood. Okay. Thank you very much. And this is a serious issue harming many children, not just California residents, but residents of other states. And there are people here who flew in from far away to speak with you later. Agenda item number 8. Thank you.
Thank you very much.
Do I have the button? Yep. Good morning. My name is Sandra Ross. I am a member of the public. I studied and have a master's degree in forensic psychology. I would like to just ask if you could consider further investigating or to put on your agenda an issue that involves claims of parental alienation syndrome versus child abuse, or versus, in particular, child sexual abuse. I know there's about a dozen states that allow the rapists of impregnated mothers to have visitation with those children. That would be a horrible thing, to allow your rapist to take and have visitation with your child. But I could tell you there's one thing worse than that, is when the child is the victim of molestation or rape by the other parent and is forced to go with that parent when the system doesn't believe that something is happening. I posted something on Facebook, and I said it hypothetically because of mandated reporters who throw these cases back into the system, back into the grind. I asked, hypothetically, what would you tell a parent who has pretty substantial belief and a reasonable belief that their child's being molested by the other parent when the system doesn't believe you and they're sending their child for visitation? What would you tell them to do in that case when the system threatens to take your child if you don't send them with the abuser? What would you do? There's not a good answer. You hear anything from homicide to run away to do this, that, and the other thing. It's a horrible thing to know that a child is being molested when they're with the other parent and the system doesn't believe you. I'm going to quote some, and I'm going to look at this so I don't mess it up. There's currently a 3-year study going on. The author of that study is Joan Mayer. She's a law professor at George Washington University. Within this study, they took a look at 230 cases where in the court, parental alienation was alleged by the perpetrator or the alleged perpetrator. Whenever that was alleged against any type of abuse allegation, they found some results that are startling and hopefully enough to look at this issue. My finger, it's like, okay, so here we go. So 238 cases that indicate where a dad was accused of abuse, in turn accused the mom of parental alienation. Of those dads, they won their cases 72% of the time just by using that counter allegation. It's become an allegation, a go-to. When there's an abuse allegation made, the counter automatically today is, say, parental alienation. And they're winning with that. So 69% of the time, when child abuse was alleged and a counter allegation of abuse was made, the parent won in that case too. But here's the startling one. In 81% of the cases where child sexual abuse was alleged, the alleged perpetrator ended up winning that case, meaning they had more increased time, overnights, unsupervised visits. 81% of the time in those cases where child sexual abuse is alleged, that child ends up with the perpetrator. Please consider at least just looking at that or questioning why would courts and psychologists who impact courts, the judges, the bench officials, listen to psychologists for advice on what to do with these cases. please, please, please look at why those numbers are out of whack. Please. Thank you.
Thank you very much. Yes, sir. Does this relate to child custody evaluation? Okay.
Good morning, Dr. Phillips, the board. Thank you for allowing me to talk today. I'm one of the people that Kathleen Russell was talking about. I just flew in yesterday from Virginia, and I'd like to just make some basic comments about the reunification camps. I've had to be involved with them just recently, deal with my particular case. I won't get into the specifics, the names and things like that. I understand that, and I don't want to get too much into my particular case. I'm just the parent of an abused child who hasn't had contact with their parent, the mother, in years. But the system is considering sending her to one of these reunification camps here in Virginia. The judge being led to believe this is just an opportunity to try to reestablish a relationship, one last chance for the mother, not understanding really what goes on at these reunification camps. So I've done some research in these camps. I just want to share with you one thing with my case that's very troubling. The judge had a conference session on the telephone with a PhD psychologist who runs one of these camps here in Virginia. And the judge mentioned, he said that after reading the report from my daughter's psychiatrist, he said to this doctor, this is the judge on the teleconference, this psychiatrist has indicated that he has met with the child. He is of the opinion that this child suffers from PTSD, and that if I require the child to become involved with this program, that it is likely to devastate the child. Now, you would expect the psychologist that runs this program to express concern over the treating psychiatrist's diagnosis and symptoms and his warnings that it would be devastating for the child. However, her reply was this: I will be very honest, the difficult part is getting extraneous therapists to understand what we do here and not dramatize the process. Does that make sense? I'm not concerned about the psychiatrist. The psychiatrist says, this is dangerous. You know, we're very supporting. We can figure this out and work through things. This psychologist showed a complete disregard for my daughter's treating psychiatrist. So I looked into these re-education camps, or these reunification camps, and I find three very significant things dealing with ethics. First is psychologists are to cooperate with other professionals in order to serve their clients or patients effectively. That's from the APA Code of Ethics. And obviously, this particular reunification camp isn't. And just the fact of what they charge, $8,000 a day, $40,000 for their 5-day program, and that's not even a residential program, that's just an 8-hour day. They're charging, and they're basically taking advantage of the court system, and they have their income coming in that way. Secondly is multiple relationships. In this case, the psychologist has contracted with an abusive mother who is paying her for the services at a rate of $8,000 a day to force the child against her will into a relationship that the abusive mother, with the abusive mother, that the child clearly does not want. The interests of the child are in direct conflict with those of the parent who has engaged the therapist. This dual role represents an unavoidable conflict that would keep my daughter's feelings, beliefs, and desires from being central during treatment. So the whole model of these reunification camps really is built into it a problem with multiple relationships. The parent paying for this wants a certain outcome, regardless of what the best interests of the child are, and these people at $8,000 a day are quite willing to achieve that outcome for the parent. And then finally, human rights. This program violates my daughter's basic human rights by forcing her to adopt a new belief system. This right is stated in the preamble of the APA ethical guidelines. It says that one's right to a belief system is considered the most basic of human rights. The confinement of my daughter, who has committed no wrongdoing, away from her parents and friends and unfamiliar surroundings at this camp in order to force her to adopt a new belief system, violates her basic civil rights. She's 17 and a half years old and almost an adult. She's been abused by her mother her whole life. At this point in time, just wants to be left alone. So in conclusion, I'd like the board to be made aware of the what's happening with these reunification camps. I was going to ask the board to issue a cease and desist order with my particular case. You'll hear of a lot of horror stories of parents that have been through what these camps have done to their children. And in my case, it hasn't happened yet. It's supposed to happen next month. So I would ask the board if they could to intervene with a cease and desist order. You have an opportunity to stop something from happening that could be cause irreparable harm to my daughter. Thank you for your time.
Thank you very much. We're now going to proceed to, oh, yeah, it stays on. Now I'm used to pushing it down. We're going to now proceed to item number 4 on the agenda, the board meeting minutes of February 9th to 10th. Are there any comments by board members? Dr. Horn?
So I just have some grammatical stuff that I'll just give y'all, but there are some things that I think are more substantive. I just want to clarify if I can. So on page 7, wait, no. Never mind. Forget page 7. On page 8, on line 360, it's workers' compensation, not conversation. Then the next one is on page 12, lines, I think line 537, it said, Dr. Horn stated that the issue may be with how the data is ordered. And I don't know what that means. So I was trying to figure out what that meant, and this is,
Can you give us a line reference again?
yeah, line 537.
Okay,
On
thank you.
page 12. We're talking about percentage of people who've seen a mental health professional prior to suicide. And I don't know what that means, and I don't remember.
Is it collected? Would that make more sense in the context of the?
It might be collected, yeah, that may be what I meant, so.
I think you were also you were talking about the relevance of that information, because some of it was about seeing their primary health provider or other professionals.
Okay, so let's just say collect, it'll be fine. I mean, it didn't make sense. So thank you for clarifying what I said. And then page 20. Line 857. So 856 and 857, this is talking about telepsych or telehealth services. Committee felt that the proposed language did not run afoul of the intent of the FTC to make available telehealth services by limitation on practice. Do we mean there, I'm not sure what we mean there. I'm not sure what that means. Do we mean intent that there would not be a limitation on practice, so it wouldn't run afoul of what the FTC wanted to do? Because it's not clear. And so,
And I think it was Dr. Erickson's statement, so perhaps he wants to shed light on
right.
what his intention was.
Just a refresher, the FTC letter was about making available telehealth or telemeans for speech pathologists and audiologists in another state. And the committee didn't feel like the language that we were proceeding with limited access to that kind of provision of healthcare.
Okay. Then
That
that makes sense now. So if we could change that wording, I think, to reflect that.
Thank you, Ms. Sorik, for helping refresh it.
And let me see, I think that's it for these, for these minutes. Hold on, yes, that's it for these minutes. Thank you.
Yeah, I have a few comments. And I know that these are very great minutes, so I just want to also ask, can we get them soon after the meeting? Because I think we forget what we say. But I just have two comments that are, I guess, more grammatical or not. But I know the members, the listing should be alphabetical, I thought, so that's not correct on both days. And on page 9, it should be Friday, February the 10th. And I'm referring to on page 1, 13 through 19, and page 9, 399 to 405, the listing of our board membership. And that's all.
Are there any other comments on the minutes?
Just on page 7, 2-7, where it says, essentially, ask, take out a word or two, ask what would the board need to do instead of what the board would need to do if it's kind of off. So just put would in front of the first part.
Just switching the woods around.
Right. So that's all you're suggesting with reference, you're not suggesting deleting any language out of it? Okay. Any other comments on the minutes? Would someone like to make a motion?
Accept the minutes with corrections, the minutes of February the 9th to 10th.
Second.
Great. Is there any public comment on the minutes? Is there any further board discussion on the minutes? Then Ms. Burns, if you'd please call the roll.
Akwebudu,
Aye.
Bernal,
Aye.
Erickson,
Aye.
Fu,
Aye.
Horn,
Aye.
Jones,
Aye.
Phillips.
Aye.
That motion carries.
Let's move on to agenda item number 5, which is approval of the board meeting minutes of April 21. Are there any comments from board members? Dr. Horn?
So again, I have some grammatical stuff, which I'll just hand to you. And I do want to echo, because I'm, frustrating this teacher here, but I want to echo what Ms. Jones said. These are great minutes. So this is in the context of them being great minutes. All righty. Page 3, line 126, Dr. Horn, I changed hope to wanted, but anyway, to remind people who will be at the opposition meeting. What opposition meeting? We're talking about,
Dr. Horn, that was the meeting that was discussed in the context of that item. There was a meeting with those that were opposing the bill, so that is
Okay.
the correct language. That was considered an opposition meeting.
okay, thank you.
I know it reads a little weird out of
Yeah,
context, but
huh?
that
Yeah.
is what it is.
Okay, thank you. And then let's see. Thank you for that clarification. Oh, on page 7, item number 6, this is Senate Bill 798, Healing Arts, boards. I think we ought to just kind of explain who the group is. It just starts off, a summary of the bill was read. She advised of current staff concerns, blah, blah, blah. We don't really say what this is about. And this was about the psychoanalysts or research psychoanalysts. And I think that just ought to be clarified in our minutes. Does that make sense, y'all? Just some sentence there that,
So I just wanted to add on to that. I mean, that makes sense. However, I think then that requires them to do it for all the others, because all the others don't have a description that way. Because I think that these minutes also mirror the memos that are attached to the board attachments. So I hear what you're saying, that would make sense when you're reading it for historical purposes. You get the context, but if that is the case, then I think we would have to do it in each of those items, which I guess I turn to staff.
I guess thank you for that, and certainly y'all can do it. We can do whatever the majority wants to do. It seems to me part of it was the title. Most titles, it's clear what it's about. This title just wasn't clear what it was about to me, and it wasn't until I read on.
Would you like research psychoanalyst in parentheses?
That would be fine. I just think it makes it clear for people who are reading it.
No, I totally agree. I just was saying for consistency, it would just go across, but that makes sense.
That may be a more elegant solution. I don't know that we necessarily want to lengthen the minutes if possible, so
No,
that
but
would be a
just
nice
if-
compromise.
That's great. Okay, another one I have is this, it's just a question I have. It's page 8, same, still the group, line 338. How many of the research psychoanalysts are licensed elsewhere? Again, I'm not sure what I meant by that. Is this in another jurisdiction or by another board or what? I'm sorry?
In other states. You're
Okay.
wondering how many other boards do that.
All right, great, thank you. And I think that's it for my clarifications.
And I think that is a great suggestion, Dr. Horn, and I would say maybe that might need to also be on another one of them, but I'll look through and share with you if the ones that need to have some clarification on the items. I had a question, I guess, from Ms. Marks about how this is in the minutes. When I look at the first page, that phone number, 897 at the Ronald Reagan Building, that's where I was located. That's not the number I used, so I wasn't sure if that needed to match the number that was the dial-in number or not.
I'm going to guess that those numbers were just taken from the agenda itself, and generally the agenda cites the phone number where someone can call for directions, not the call-in number.
Okay.
So it would be up to the board whether or not you felt like those addresses for the minutes needed to also include those phone numbers. As you suggest, it might be a little bit confusing, as opposed to the address where someone is calling in from, which I think is important for a teleconference meeting, and to have the minutes reflect that.
Thank you. Yeah, I was just thinking that, because I would say, I never paid attention to that. Now I'm trying to be like Dr. Horn and look at the minutes closer. I would say, that
In some cases, that would be a private cell number that you wouldn't want in the minutes, I suspect, so I think it's better the way it is.
and that's what I was thinking, the same thing.
I think if I understood Ms. Marks, she was saying that it didn't need to be a telephone number at all. So if that's the case, then we don't have to worry about whether it's private or public.
Right, but I do think that on the agendas, the practice is to put a phone number where someone can call to get directions to the location for a teleconference meeting.
So I would scratch off the number, definitely in Los Angeles, for that day on page 1. And on the last page, on 15, for the adjournment, I think it's important to add, the board returned to open session, but was unable to establish a quorum due to technical challenges related to the conference line. Because I know that folks called back, I was one of those, and no one clicked in, so that's why I departed. And that's all I have, Dr. Phillips.
Thank you. Any further comments on the minutes? Would someone like to make a motion?
I second.
Thank you.
Ms. Akwe-Badu, you mean submit, you mean approved by the board?
Yes,
Yeah.
approved by the board with corrections as stated.
Does your second still stand, Dr. Horn?
Yes.
Oh,
I
Ms.
second.
Bernal?
Yes.
Okay, thank you very much. Any public comment on the minutes? Any further board discussion on the motion? Ms. Burns, could you please take the roll?
Akwe-Badu?
Yes.
Bernal?
Yes.
Erickson?
Yes.
Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Our motion carries.
The next item on the agenda, which we're taking out of order, is item number 7, the enforcement report. Ms. Monterrubio?
Okay, the enforcement report is item number 7. And it's a little bit lengthier than normal. I just wanted to give somewhat of a more... Yes? Okay. I'm giving more of an overview of the entire fiscal year, so I'm going to talk about enforcement staff, their... Is that better? Okay, thank you. I'm going to go over the enforcement staff, their responsibilities, the complaint program, the investigative program, citation program, discipline program, and our probation program. And at the end of the report, we have the overview of enforcement activity as well as the performance measures for quarter 2. The enforcement unit consists of 1 manager and 7 staff. Staff includes an office technician, 4 enforcement analysts, a special investigator, and a probation monitor. The office technician opens and assigns all complaints received. The enforcement analyst performs desk investigations. The special investigator conducts formal investigations, and the probation monitor monitors all probationers. The manager oversees the unit by meeting with staff to answer related questions and concerns, reviews and approves cases being referred for formal investigation, formal discipline, and closure. The analysts perform desk investigations by reviewing complaints, gathering evidence, and referring cases to subject matter experts, board special investigator, health quality investigative unit, the Division of Investigation, and the Office of the Attorney General for formal discipline. If a case is referred to a subject matter expert, the analyst provides a complete copy of the case file and requests the expert to opine as to whether or not a violation occurred. If the expert determines there was a violation, the case may result in an educational letter, citation and fine, or formal discipline. If the expert determines the standard of care was acceptable, the case is closed and no further action is anticipated. The board's special investigator investigates cases referred by an enforcement analyst. The SI interviews the respondent, complainant as needed, witnesses, gathers evidence, and prepares an investigative report detailing the findings of the investigation. Once the investigation is complete, the matter is referred back to the analyst to determine if there is enough evidence to issue a citation and fine or refer the matter to the Office of the Attorney General for formal discipline. If there is not enough evidence to take an enforcement action, the case is closed. If a citation and fine is issued, the licensee can appeal the citation through an informal conference and/or request a formal hearing. If an informal conference is requested, the licensee can appear in person at the board office, submit written argument, or schedule a conference call. Formal hearings are heard before an administrative law judge. In these circumstances, the Office of the Attorney General represents the board. Once the case is heard, the administrative law judge will write a proposed decision and submit his or her recommendation to the board. The board members will decide whether to adopt or non-adopt the ALJ's recommendation. If an investigation determines there is enough evidence to prove the licensee or applicant departed from the standard of care and formal discipline is warranted, the case is referred to the Office of the Attorney General for a filing of an accusation or statement of issues. After a licensee or applicant has been disciplined, the subject is placed on probation and monitored by the board's probation monitor. Since July 1st of 2016, the board has received 1,042 complaints, which is an increase of 31% from last fiscal year. Complaints can be submitted online, via fax, or mailed to the board. All complaints received are open and assigned to an enforcement analyst. On average, the intake process is completed within 7 days of receipt of the complaint. In May 2016, the Chief of the Division of Investigation, David Criss, and Deputy Chief of the Health Quality Investigative Unit, Kathleen Nichols, met with the Executive Officer and the Enforcement Program Manager to discuss the prolonged investigative timeframes with HQIU and whether or not the board would consider a one-year pilot program with DFI in order to reduce investigative timeframes. The board agreed to a one-year pilot program in July 2016 and began referring cases to DFI. To date, approximately 175 cases have been referred to DFI, and the average time to complete those cases have been 12 months. As a result of DFI's ability to significantly reduce investigative timeframes in half, the board agreed in May 2017 to another one-year contract. The executive officer and the enforcement manager will meet with DFI representatives every 6 months to discuss the processing of cases. The board does continue to refer cases to HQIU that involve sexual misconduct. As previously described, desk investigations are performed by enforcement analysts. Formal investigations are performed by the board's SI, HQIU, and DFI. Investigations that require a sworn peace officer because of criminal activity or safety concerns are referred to HQIU or DFI and not the board's SI. Since July 1st, 2016, the board has issued 32 enforcement citations. Citation and fines are issued for minor violations and do not require formal discipline. For example, false or misleading advertising and minor record-keeping violations are considered minor violations. Since July 1st, 2016, the board has referred 45 cases to the Office of the Attorney General for formal discipline. There are currently 52 active probationers and 45 told probationers. Active monitoring is ensuring that each probationer is complying with each of the terms and conditions of probation, which includes meeting with each new probationer at onset of probation to discuss all of the terms and conditions of their probation, discussing the status of the probation, and providing early termination information, conducting a quarterly audit of each probation file, and answering questions to probationers. There have been 16 individuals whose license registration has been placed on probation within the last fiscal year. If a probationer is out of compliance, the board may issue a citation and fine or refer the matter to the Office of the Attorney General for further discipline of their license. For minor violations, the probationer will most likely be issued a citation and fine, which can include an order of abatement to correct the noncompliance. For more egregious violations or accumulation of minor violations, the case would be referred to the Office of the Attorney General for possible revocation or an extension of probation. The most common probation violations include, but are not limited to, the following: failing to check into First Lab, which is our drug testing vendor, missing a selected drug test, not obeying all laws, failing to notify the board of any changes in employment, failing to submit cost recovery payments, missing coursework, submitting quarterly reports late. And attached is the overview of enforcement activity displaying complaints and investigation timeframes, as well as the most recent performance measures. Any questions?
I have a question, and I'm just curious. You said that the board does not, or does continue to refer cases to HQIU that involve sexual misconduct. I'm just curious why you're continuing to use HQIU for those cases.
Cases that require vertical enforcement, and that's where the Office of the Attorney General is working with the investigative unit right from the start. They're helping the investigators with what evidence needs to be gathered. HQIU works for vertical enforcement cases, D of I does not. And so for sexual misconduct cases, which are pretty much the most egregious type of cases the board receives, we like for the AG's office to be involved from the very beginning. So
But
those
it's
cases
also
are referred.
It's also has the longest delay time. I mean, I understand what you're saying, but it's kind of
Right, and
Right.
those particular cases that are with HQIU are most likely being worked in a much faster way because the majority of our cases are going to D of I.
okay.
So very few are being referred over to HQIU, but those are the sexual misconduct cases.
Thanks.
Sure.
I guess following up on that comment from Dr. Horn, in terms of the time processing currently with IU, sorry. And so since that it's diminished because other cases are being, elsewhere at DOI, what is that timetable now? Because those are the most egregious cases, and so what's the delay, or not delay, but the timetable?
Well, HQIU does have several vacancies, unfortunately, so our cases that are being referred over are probably now still looking at 12 to, I'm going to say 18 months. But again, because sexual conduct falls within the vertical enforcement process, we do refer those over.
So, and I appreciate the understanding about the kind of the staffing currently, so what can we do as a board to, I guess, explain the nature of the cases that are going now, that they're so egregious that that timetable is, I would say, a little problematic. I think it's great that we've reduced it on the other side, but if the most egregious ones are still being, they're facing a longer timetable, I mean, what can we do? Or is there anything we can do?
Well, I'm not really sure if anything that the board can do. I think that falls more on the responsibility of staff. And the enforcement staff is checking with the investigative units every 30 days. They get assigned within 90, and every 30 days, my staff is checking on their casework. They're checking with the AG's office as well as with the investigative unit. So we're doing the best that we can with the resources that are available through HQIU. And I think eventually, those processing times will be a lot better as well once they start hiring additional people. But the enforcement unit does follow up every 30 days on every single case with both units.
Would it be helpful at all and I mean, it sounds like y'all are doing a good job and the best you can. I'm wondering if it would be helpful at all if next 30 days you went and said, hey, the board is really concerned about this. Just wanted to let you know, just kind of drop it in there, that we're asking about it because it is such an egregious thing.
No, absolutely. And
Okay.
Antoinette and I do meet with Kathleen Nichols. She's very responsive. She's a deputy chief of HQIU, so we definitely can have a conversation with her as well. But we try to be mindful of, again, the challenges that they're facing with having so many shortages there as well.
I guess my thought is, I know in terms of your notion about the vertical case, and I understand the resources, so I also am saying the same thing too, that I am not pointing a finger in any way. But I just feel like in terms of how we get this kind of through the process is important, and I don't know if there would be a way for then, with and this is probably way above my understanding here, but the way in which we use our SIs, is there a way to get a higher level SI in-house to be able to do this kind of work? It just seems to me that, given some of the comments we've heard at recent meetings about the different nature of cases and the timetable, it seems like if there's something we could think outside the box to solve it, it might be worth the effort. And I don't want to say Kathleen Nichols, I'm sure, is doing a great job, and I know that it's great to hear that we have another one-year contract to do the DOI connection, but is there any other way? It just seems like, can we explore it when you guys meet with them the next time or something like that? I don't know.
Absolutely. When any case comes in, we first obviously take a look at that case and determine where it should be assigned. Should it be with HQIU, D of I, or with our special investigator? So yes, our special investigator that's in-house can work certain types of cases. An example of that is petition cases. Those used to always go to HQIU, and we're taking 9 months. So somebody would petition the board for, let's say, early termination, but the actual investigative review would take 9 months. We now give that to our SI, and the turnaround time was 45 days. So every case that comes in, we analyze and we determine what is the best route for that case to take. And yes, we could have our SI look into the sexual misconduct cases, depending on what those allegations are.
And briefly, the Department of Consumer Affairs is trying to remedy the long turnaround times in a two-pronged effort. There's a legislative effort to not require that all cases necessarily need to be vertical enforcement. I'm looking at our DAG liaison because I know the AG's office has been working with the department on that side of things, which would potentially affect the timeframes of cases. One other prong that they are using to address the situation is the pay of investigators. I know there's a request to increase the pay for the HQIU investigators so they can retain investigators for a longer period of time. It's the high vacancy rate that's really having a major impact on the case timeframes.
You referenced the 31% increase of complaints from last fiscal year. Are we able to determine what's driving that increase? It seems the average is looked around usually in the 700s. So is there increased outreach that we've done in the process? Are we able to determine that increase?
We're looking into that, but I'm not quite sure today why exactly the 31% increase. We are receiving more complaints from inmates, and we do investigate those as well. So that may be the increase, but we're looking into that, and I'll be able to report more on that in September.
Thank you.
Any further questions or comments as to item number 7?
I wanted to thank you for a nice report. I enjoyed reading it earlier this morning, and it was nice to have some clarity about the discipline process, so thank you.
You're welcome.
I'm sorry.
And I didn't see Mr. Tom Play in the back. Congratulations on your wedding.
Do we have any public comments on item number 7? Come forward. Thanks.
There we go. I understand when the board receives a complaint, it'll need to go to an investigative agency for a complete investigation, but do you have a process where if you get a complaint, where it's clear in the complaint that there's imminent harm or danger that can be done to a patient, where the board could take some kind of an interim step to stop the process until the full investigative process can take place, such as like a cease and desist order or some kind of action, at least the board can take initially, short of the full investigation, to stop maybe something happening that could be harmful to a patient?
There are times in which the board can seek what's called an interim suspension order. It does not take the place of formal investigation. The board is still going to have the sufficient evidence to go forward with an accusation for the discipline of the license, and that it tends to be done on a more expedited basis, so the board has to have sufficient evidence in advance of even going forward with the ISO, the interim suspension order.
Sure. To speak about the same, yes, there is a procedure available if you have sufficient evidence of an imminent threat to the public or to patients. You can proceed, as the council has said, with a interim suspension order.
Further comments or questions from the public?
Yes, I just have a question about the procedure for an ISO. What is the procedure? Where is that available? And in terms of what is sufficient evidence, where would a member of the public go to get that information?
Hi, Josh Tomplay. I'm a Deputy Attorney General. I work with the board on enforcement matters, and I can refer you privately to the laws that set that out.
Okay, thank you.
I'm looking for the infamous button. Is this working without me pushing it? Yes, okay, good day. Okay, so my name is Kimberly Swady. I was originally going to speak on item number 8, but as I'm learning, this is the first board meeting I've been to, and I'm listening to this presentation, I'm going to challenge you today. Because you're mental health professionals, I got to believe that you're really interested in cutting edge health, okay? And the hardest thing for human beings to admit is that they're wrong. And we're going to be talking about this a little bit more today. My background is I'm an attorney. I haven't practiced for about 25 years until recently because I left kind of in disgust. I also have an MBA from the Wharton School. So I'm going to challenge you today. Professional therapy never includes sex. And I've heard it referred to here under this action item that these are the most egregious cases. I disagree. I completely disagree. How are these the most egregious cases? Now understand, as a professional, the idea of me ever having sex, I'm not a psychologist, but I'm a lawyer, having sex with one of my clients is completely unacceptable and should be grounds for immediate disbarment, in my opinion. And I think the same should go for psychologists. However, this is not as bad as a therapist who's doing evaluations, well aware of the fact that one of the children is being subjected to sex by their parent. So how about we have a brochure that says, proper parenting never includes sex. That is far more egregious. As a woman, I would find it much more damaging to me if my child were being sexually abused by their parent, or anyone's child was being sexually abused by their parent, than if I myself was being abused by my psychologist, because I'm a grown adult. Now, I'm not going to say it's pleasant, I'm not going to say it's okay, but if we're going to be weighing harm, doing things to children is far worse. So I'm going to challenge you to rethink that these are your most egregious cases. I completely disagree. Number 2.
If you're going to continue to speak to that particular subject, unfortunately, that's not agendized. That booklet's not agendized. We'd be happy to put it on a future agenda.
I would love to have that issue debated on a future agenda, because when I sit here and hear these are the most egregious cases, I'm just going to tell you, I disagree. I don't think they're the most egregious cases.
Okay, but we need to stay within the context of the agenda.
The context of the agenda, there's no line item here for, under complaints received, of how many complaints are I don't want to call them duplicate, but how many people are being complained about that are unique individuals. In other words, are there psychologists or licensed people that have multiple complaints against them? You have a number here in 2016-17 of 1,042. I've got to believe that there are individuals who are being complained about by multiple people who do not know each other, and that would be a very interesting piece of information for us to know and understand. Is the board being alerted to the fact that there are certain individuals who are coming to the attention of the board repeatedly? Because to me, that is much more telling than isolated complaints. This is data, this is information, this is something that we need to look at. Another issue of concern in this whole thing is, and I'm new to the terminology, so I didn't understand much of some of the acronyms and abbreviations. But I'm extremely concerned with my background in business. I think I mentioned I have an MBA from the Wharton School in strategic and financial management. I'm extremely confused and concerned about the credentials and qualifications of people that are doing all of this analysis of professionals' behavior. In my opinion, from the get-go, this should only be looked at by peers, and preferably peers from another state that have no vested interest in the outcome, and these should be recognized people. The idea that we have, and my understanding has come to light, that we have people doing investigations that are lay people, we have people doing investigations that might be nurses with expired licenses. All of this is completely unacceptable from a professional level, and that is a grave concern in how effective the analysis and the entire discipline process is going to be. So from the get-go, this needs to be transparent, and we need to bump this up, like really seriously. I'm going to address many more issues under the item 8, and going back to we're just on the wrong path, both judicially and psychology. But just sitting here today with this, these are some of the issues that came up. So I'm going to challenge you to say, guess what? Because you're the mental health board and psychologist, I'm going to challenge you to rethink some of your assumptions. And I've brought some of them up today, and there are going to be more as I become more knowledgeable about your function, what you do, and the premises that you operate on. I'm going to continue to challenge you because that's my job as a member of the public. Thank you.
Thank you very much. Dr. Horn?
So, kind of following up on that comment that was just made, or one aspect of that comment about how many individual people does this represent versus number of complaints, or how many, like, psychologists do these complaints represent. I think that's maybe a good idea to include that statistic in there. Doesn't necessarily, well, obviously, I don't have to say any more than that. I think that's a good idea, if we could add that.
Maybe we can discuss that in the next enforcement committee meeting.
Catherine Campbell, thank you for this line item. I appreciate hearing more about how the process works, and I just want to bring to your attention how important each complaint is. And sometimes I feel as if the number of complaints goes up and you don't have more people reviewing these, their valid complaints are being sidestepped. They're just kind of saying, this doesn't sound right. I certainly know when I went recently to Sacramento, they were trying to not have as many people on the list of child abusers. And they said, oh, if it's just a misdemeanor, it shouldn't be on there. And because there's too many. The list is too big of child abusers. And what we need to remember is every abuse to a child matters. And we shouldn't discount it because there's too many, or it doesn't seem as if there's enough immediate information on it. Everyone matters. So every complaint is very important. And I never want to know that a complaint has been dismissed because it doesn't seem valid in the beginning. It just seems as if the number of complaints versus the number of actions taken by the board to ensure that the psychologist is doing the right job doesn't equate. It just seems as if, and I do know people think there's so many, we just, take a percentage. It's very important just to remember each one matters. One person affected by a psychologist matters. And what happens is that can be repeated to other patients of that psychologist. And if we only have, 20,000, that's, our numbers are going up. Our numbers are going up of people who are hurt, who need psychologists. We know with the ACE study, these children are growing up with many disabilities that are preventable, and when they're not serviced through psychologists, it continues to damage that child. and into an adult, and it will continue to damage adults. So my request is just that we don't discount one because our volume is going up. Thank you.
I did want to respond briefly to what you're saying. And first of all, I want to say thank you very much for your comments. They were very thoughtful. However, I think the enforcement staff takes every complaint incredibly seriously. So I do want to say that it's a very dedicated group of people who are very earnest about their enforcement function. That's why they've gone into enforcement, not to just kind of process numbers and spend a day at work. That's not the people that we have on our staff. I would also like to reassure you that if we felt that the volume of cases was such that current staff could not meet that, then we would request a budget change in order to allow the hiring of additional staff analysts. But I did want to reassure you that these are very serious-minded people that take their duty to the public very seriously.
And may I reply to that? I appreciate that. And when I come, this is my second board meeting, and when I come here, I can just see all of you and how much it matters to each of you. And that's reassuring. That's reassuring to us. But when we hear of complaints that aren't being processed and receive a short paragraph that their complaint is not valid when we know it is, that's not reassuring. And I have seen those letters, and I have seen the evidence that was submitted in a complaint, and that is why I'm here. And because I know all of you want that, and I know all of us want that, and I just don't think that's the reality. So I appreciate you wanting it to be one way. I think we need to be authentic about what is really happening.
But I also want to share with you my experience of the enforcement function of the board, and that is that all claims are processed and serious considerations given to what evidence is available. You may not necessarily agree with the results of that determination, but it is not my experience that people just summarily dismiss complaints without giving them consideration.
Thank you.
May I just echo what you're saying as well, and also to just make you aware that it's a process. Unfortunately, it takes more time than we would like, but we're working toward making it better and better each and every time. I just, in concert with what you said, I think I needed to say that as well.
And I also wanted to say, Ms. Monterrubio, I think you and your staff do a fantastic job. And I also, just hearing those two public comment statements, I feel like you did probably maybe last year this time an overview of how you select individuals that review. I feel like we might need to agendize that again so that we can talk about that, because I know that there were 2 classes of folks that went through the process, I think. Was it 2 or 1? I can't remember. It was 1. So it'd be great to talk about that again, that process. And the other just comment that the last comment brings to mind for me is, in terms of those that get processed and aren't fully processed, and they get there's not enough evidence to move forward. Have we ever done any kind of analysis about folks that then come back through the process that then get a fuller investigation because there's more evidence, just out of curiosity? And I know that we just talked about the question that Mr. Fu raised about, how do we know what's moving up? But in terms of data points, that might be something down the line. I don't know how much work that would require, but I just feel like that might be a comment that comes to my mind from that last statement. And I don't know if you have a thought on that, Ms. Monterrubio.
Just so that I'm clear, you want us to be able to provide information on cases that weren't fully processed, but then the complainant came back and their complaint was fully investigated?
So I don't know if that is what my data point is, but I feel like, have we done any review of that? Do we have any kind of data on that? Do people come back through that have been initially? It kind of goes to the comment of Dr. Horn saying, in terms of unduplicated numbers here, is it the psychologist or is it a complaint? Does that person who may not have been fully processed, what do we do with the data?
You're talking about
the psychologist, maybe there's a complaint against a particular psychologist, if I'm hearing you
Yeah,
right?
let me get it out, all the way out. So if the psychologist, if the complaint is made against the psychologist and it's not processed forward, and then another complaint comes back for that same person, do we track that at all? Because I know that when we're reviewing cases, we can also see if people have been, if discipline or complaints have been brought up against them before, do we track those folks at all in any way?
Just so I'm clear, are you saying the same complainant comes back?
No,
Or you're saying the
sa-
same licensee?
The licensee, the
Okay.
complaint against the licensee comes back.
Well, we do look at the enforcement history anytime a complaint is submitted. We like to see if the same type of allegations are being made. That hasn't been reported to the board, but it is something that the enforcement staff looks at every single time they open a complaint. And I just want to be clear on fully processed or being processed. We process all complaints.
I'm sorry, that's the wrong terminology.
Sure.
It's not moved forward into an actual case being opened. It gets closed at the initial complaint.
And a case would only be closed without moving forward with a desk investigation or a formal investigation or an expert review is if a complainant didn't provide us everything that we needed. We send out a letter saying within the next 10 days, please provide the following information. If we don't hear anything, we close the case, we keep it on file, and we wait for the complainant to provide additional information. Now, a respondent doesn't have that option. If a respondent doesn't give us the records, we'll take action. But for a complainant, we need enough information to initiate an investigation. And if we don't get that, we do have to close and we have to wait for the complainant. And sometimes we'll get the documents that we asked for months later, we open the investigation and we proceed forward. But we process all complaints.
I'm sorry, but that was the gist I was saying. So I guess the question might be then, I mean, I think you can do the math, but maybe it would be more clear for transparency's sake to have a line of those that no more information was received. Because in terms of that, is that change from year to year? I mean, I don't know, I just feel like the public comments just strike me in terms of us being able, I know you all do a fantastic job, but I just feel like maybe that might be a way to communicate that out. That the fact that some of them are not, you look like I'm confusing you.
No, I've heard some of the comments today, and I understand that we have a high number of complaints that were submitted this fiscal year, and from what I'm hearing is the board maybe wants me to explain more of the 1,042. How many of those are against the same psychologist? How many of those are complaints where we didn't move forward because we didn't get enough information from the complainant?
Yes.
So I'm clear as to what the board wants, and I'm happy to report that in September at our next board meeting.
Ms. Monterrubio, wouldn't some of the complaints also be closed immediately because the board doesn't have jurisdiction over that kind of complaint?
Absolutely.
And so that would also make that number a little bit higher, such as somebody who complains that the psychologist charged them too much money for the going rate or something along those
Right,
lines.
there's-
The board would not take action against those or investigate those.
Correct. We don't have jurisdiction over, obviously, licensees out of California, billing, fee disputes, things of that nature. So yes,
Could that also, that would be articulated in the report,
I can include that as well.
in the data?
Yes.
Very well, thank you.
So I have one more thing. I'm going to ask this of the enforcement committee. Is there a separate enforcement committee report? Okay, well then I'll just wait. Never mind.
Dr. Phillips, I just need to make a quick correction to my previous comments. I'm sorry, I had to deviate from my notes because to stay within your guidelines on specifics, but I guess it was brought to my attention several times I mentioned the programs in Virginia, and I meant to say California. We don't have these in Virginia. It seems to be a California phenomenon. But I just want to be very clear to you, I was talking about programs that are operated within the state of California and that fall under your jurisdiction and oversight.
Thank you for that clarification. Any further comments from the board on this subject? We're going to take a short break, but before we take a break, I'd like to see a show of hands, if possible, and you don't have to put your hand up if you don't want to, of how many people intend to make public comment on item number 8. 1, 2, 3, 4, 5. Anyone else? So 5. So that'll help me to plan how much time I'm able to allocate to each of you, because we do have a very full agenda, but we also want to hear your comments. Thank you very much. We'll take a 10-minute break. Okay, we're going to move to agenda item number 8, and first we will hear from Ms. Monterrubio. I do want to remind people, members of the public that want to speak, of kind of the following guidelines, and if for some reason you forget, I'll be happy to remind you again. We're going to give you about 5 minutes each for your comments. That 5 minutes will be, we would prefer that you not mention the name of any licensees during the course of your comments. Otherwise, it makes it very difficult should one of those licensees come before the board on a complaint that might be pending. So we prefer not to talk about pending complaints and not to speak about specific licensees by name, and to restrict your comments to 5 minutes. And if something's been said by somebody already, it's not necessary for you, and we've heard it, it's not necessary for you to repeat that. You might want to move on to new material but so far that has not presented a problem today. So first, Ms. Monterrubio.
Okay, at the February board meeting, the Board of Psychology received public comment regarding its handling of child custody evaluation cases. The board is a consumer protection agency and is committed to protecting consumers of California from potentially harmful licensees and practices. In keeping with its mandate to protect consumers of psychological services, the board processes child custody evaluations in the following manner. An assigned enforcement analyst reviews the complaint. The analyst checks the subject's complaint history and notes any trends, reoccurring allegations. The analyst requests additional documents, information from the complainant if necessary. If the complainant does not respond to the analyst's request for information, documents, the case will be closed until everything is received. If the complainant provides all requested information, documentation, but says they don't have custody or can't sign the release form, the analyst will proceed with the case. The analyst obtains the non-complaining parent's contact information from the complainant, the mailing address, if not provided in the original complaint. The analyst writes to the subject requesting a response to the allegations and the provision of records. Notification is sent to the non-complaining parent pursuant to BMP Code 129, subsection F. If the subject does not provide records, the analyst will prepare a subpoena for the records. The analyst can receive a copy of the child custody evaluation report in accordance with Family Code 3025.5. If there are objections to the subpoena, a complete copy of the case will be referred to the Office of the Attorney General for subpoena enforcement. The analyst will conduct a thorough review of all case materials to determine if proceeding with a field investigation is warranted or if the case should be closed. If needed, an expert will be consulted. When the expert consultation is received, the analyst will review it to determine if the case should be referred to the field for further investigation or closed. If a field investigation is warranted, the case will be transmitted to the Division of Investigation. When the field investigation is complete, the analyst will review DFI's investigative report and determine if an expert review is required. If an expert review is conducted, the expert report will be reviewed to determine if the case should be referred to the Office of the Attorney General for disciplinary action. If an expert opines that there are departures from the standard of care, the case is transmitted to the AG for a filing of an accusation. If at any time it is determined that the case warrants closure due to insufficient evidence or no violation being found, the parties will be notified in writing. Any questions?
I just have one question. When you talk about subject, you're talking about the psychologist?
Yes, the licensee.
Okay. Could be a psych assistant or somebody such.
Correct.
Right.
Any other questions from the board of Ms. Monterrubio? Sure. Ms. Monterrubio, maybe just for purposes of illumination, you could help us to understand what you mean when you use the word insufficient evidence. Maybe you could give a couple examples, which are not actually in pending cases.
Well, insufficient evidence, again, is just when we close a case, insufficient evidence, it means that we know that something, we believe something may have happened. We just don't have the evidence to prove that something occurred. We aren't able to forward that over to the AG's office because they won't be able to file an accusation. But again, we have subject matter experts review all of our cases regarding child custody. If they need additional information, we will contact the subject, we will contact the complainant for that documentation if it's available.
Okay, maybe more specifically, could you give us an example of a case in which the evidence would be considered insufficient, or circumstances under which you would be forced to come to that conclusion? And maybe that's not a fair question, but I'll ask it anyway.
I'm trying to think for child custody when we've closed it, insufficient evidence and what type of documentation is missing.
Can we,
I'm sorry, go ahead.
while you're thinking, I'm just wondering, can that be a question that we can answer perhaps the next time that we meet? And you will have examples, specific examples of that? So instead of kind of moving it forward now, give us more time with an alignment with the enforcement.
Let me try it this way, Ms. Monterrubio. You mentioned cases in which you will ask the complainant for additional information or documentation. Can you give us an idea of what kind of information you're looking for and what you're not getting back?
There are times that we're not getting the 730. We might not get the release form, but again, we're moving forward with those.
And the 730 would be the formal custody evaluation?
Yes.
Okay.
I think there's also court-appointed documents that we would like to get as well. So those things, if we don't have, we will close insufficient evidence, wait for those documents to be submitted by the complainant, and then move forward. But I just want to be clear, even if we don't get a release form signed, we're still able to move forward.
Thank you, that's helpful
Sure.
to me.
Could we still, and we will, the enforcement committee could put together other examples of that as well? I mean, after the enforcement committee meeting, could we outline some of the other documents that you might would need to get back? Just a question.
Sure. I mean, I think that we could jot down certain things that we would like to receive from the complainant that would be helpful, and things that we need in order to move forward with our investigation. I can definitely provide those examples.
Maybe the appropriate forum would be at the next enforcement committee meeting. Maybe we can discuss that, and to the extent it feels useful, bring it back to the next board meeting.
That's what I said, the
Okay.
next enforcement committee meeting. I mean, the next enforcement.
That's what I
Right.
heard.
Okay,
Okay, thanks.
all right.
Thank you.
Maybe I'm not listening well this morning.
Yes, you are.
Any other comments from the board?
I'd like to make a comment or a question. If I understood that the way the process works many times, the evidence comes in and we decide at the board level whether there's sufficient evidence to move to the AG's office.
Well, it doesn't ever go from board staff to the AG's office. There's a subject matter expert that is involved. So once the complaint is filed and we get all of the necessary documents, we then forward it over to an SME, who is a licensed psychologist. He or she will review the information provided and opine as to whether or not there is a departure from the standard of care. If there is, and it's egregious enough, we'll move forward to the Office of the Attorney General for formal discipline.
I think what I wanted to key on is whether it's egregious enough or sufficient enough. And I believe the parallel, and I want to check, is like in local jurisdictions, the district attorney files charges against someone if they have enough evidence, and if they don't, they have to drop the case. And is it something similar for this kind of civil matter in terms of licensure?
I would say so, and I just want to be very clear with what board staff does and what the investigative unit does and what the SMEs do. So when the complaint is filed, again, board staff is just collecting all of the evidence, all of the necessary documents that we know our SME is going to need to review. And once everything is submitted to us, it can go to our SME for review, possibly formal investigation, and then to the Office of the Attorney General. There are times that the SME is not going to find that there was a departure, and we're going to close that case out without ever going to the AG or going to a formal investigation. Just based on the documents that were provided by both parties, we're going to close that case because the SME decided that, or determined that there was not a departure.
And when you say SME, you're referring to
Subject matter expert,
Okay,
yes.
thank you.
And I just wanted to clarify something that, that Dr. Erickson touched on when you mentioned a civil matter. These are administrative matters, and that, yeah, and that the board's burden of proving basis for discipline is done at a higher standard than for a civil matter. It's to the clear and convincing evidence standard and not to the preponderance of the evidence standard that is in a civil matter.
And if it's helpful, Dr. Erickson, thank you, Ms. Marks. I was going to say the same thing. The standard that we at the Attorney General's office are required to adhere to prosecute a case is to form the belief that we have clear and convincing evidence of a violation being a departure from the standard of care. And so we generally then will need an expert's opinion to set forth a departure and enough evidence to meet that clear and convincing standard for us to prosecute.
And the point is probably obvious. We've heard from testimony from people here as public members concerned that something wrong has happened, and why don't we do anything about it? Sometimes there may be something that looks wrong, but we don't have enough to work with to do something. And it's unfortunate. Other times, we discipline, and it still may not satisfy one of the parties, but it seems that we're doing a thorough job with this, and it doesn't always meet the answers and concerns of people that have complaints. Thank you.
Thank you, Dr. Erickson, for your question, because I think that's what I wanted to pick up what you said, Ms. Monterrubio, when you said sometimes we see something that's there, but we don't have sufficient evidence. It is that notion of clear and convincing evidence, as Ms. Marks and Mr. Tomplay said. But in terms of the way that gets communicated back out, does that get communicated, the whole idea of an administrative matter and kind of the level of evidence that is required to actually adjudicate discipline or adjudicate in general?
We actually have form letters that we send out when we're closing a case, and if it's closed, no violation, we tell them that there hasn't been a departure from the standard of care and the matter is closed. Insufficient evidence, I believe, also states that there wasn't enough evidence to move forward. We don't provide specific information that we would need to move forward. So it is very general, but that's how our closure letters are written.
So, thank you. And it sounds to me, in terms of, it would be great, as you were mentioning your upcoming enforcement committee meeting, Mr. Quaybadu, it would be great to be able to see these standard letters that people are seeing. It might just help educate me as a board member, but also to maybe review to see if there's a way that we could address some of the public testimony we're hearing to make it a little bit general, because we have the legal requirement, of course, but to be able to be a little bit more transparent and clarifying.
So, remember earlier when I said, are we going to have an enforcement committee report? So here's what I was going to say, that I'd like y'all to have at your next committee meeting reviewing the letters that go out. So, anyway,
Well,
just... Okay, thanks. So I kind of want to follow up, because what I heard in the initial public comment, and certainly want to hear what y'all have to say again about this issue. But one of the things I do want to follow up on, because there seemed to be some misunderstanding about what the board can do and what we can't do. So anything that we do in terms of say, psychological practice that might be harmful or unwarranted or any kind of thing like that has to originate from a complaint. We can't take action without a complaint. So we can't even look at something unless we receive a complaint. And one of the things that Ms. Monterrubio was talking about is there are certain times when we'll proceed anyway, even if we don't have everybody's consent or anything like that. It's fine for us to proceed with just one complainant, say in a custody situation or a custody evaluation if there's a complaint against a psychologist. But a lot of times we end up having to wait or close a case because the person who has complained maybe hasn't given us the information we need to continue to go forward. We're also restricted in terms of the kinds of things we can actually look at or we can do. So we are looking at, if there's a complaint, if there's a concern about the standard of care, that we can take a look at, we can evaluate. That's, what our enforcement committee or our enforcement staff will take a look at and get expert opinion on it, or something, something like that. Or this was a multiple relationship that shouldn't have happened. I'm using some of the things that y'all talked about. But those kinds of things need to be alleged. It can't be, I don't know exactly what I want to say. It needs to be a specific complaint about a psychologist. What did this psychologist do that you felt was unfair or wrong? Did this person make a recommendation without seeing everybody? That would be something that we could investigate, for example. That's a specific complaint, and making recommendations about somebody that psychologist hadn't seen or something like that. I'm just kind of trying to think of the kinds of things. So I do want to say that. And every complaint is investigated thoroughly and only is stopped for very specific reasons. We go as far as we can, and we use the code of ethics. We use the standard of care. We use guidelines to for psychologists that we go by and our experts go by to help us move forward or help the staff move forward with things. So I just want to let y'all know. So for example, this, like when you're talking about a community, I forgot what it's called, but where a reunification camp or something like this, we have zero control, over those camps. I don't even know who you would complain about, but if there's a psychologist that you have concerns about who's working in that camp, that's the complaint. We have zero to do with whether somebody gets sent there. So I just kind of wanted to let you know so there's not any confusion about what we're allowed to do as a board, what our purview is, and what we just have absolutely no ability to decide about.
And there'll be time for public comment.
Yeah.
To restate what you're saying, we license and regulate the practice of psychology, and we have licensees and we have registrants, and we have jurisdiction over them. We do not have jurisdiction over the courts. We do not have jurisdiction over facilities. Those things are all, to the extent they're regulated by other agencies. So what we can look at, as Dr. Herm was saying, is complaints against specific licensees, but we don't, sometimes I feel like people attribute to us a power that we don't have because it's not within our purview.
Thank you.
I just also want to add that as a member, as a public member that I was appointed to, and now we have three, Mr. Kwebadu, Mr. Fu, and myself. It is, and, oh, that's right, I'm sorry, 4 now of the public that are here also in conjunction with the professionals so that I want the public to know also that there's a good balance, so there's no one that's just, protecting the profession, or it's just not one group protecting the professionals.
In addition to the comments by Dr. Horn, I think examples of what those departures of care might look like. So I think you referenced, for example, not interviewing everybody as an example of what a departure of care would look like. So perhaps not just for us, but for the audience at the next meeting, perhaps, to have examples of some of that as a part of the larger discussion might be helpful.
And when we say not interviewing everybody, I think what Dr. Horn's really referring to is diagnosing people that have not been seen by the psychologist. That's the primary concern there. A psychologist is not obligated to interview every family member in every situation, thank God. But if to the extent they're going to opine on someone, they do need to have had contact with them and have a data set that will justify them coming to some kind of conclusion.
And I did have one other note when I read through my board book, and it sounds like we have given a lot of assignments or suggestions for the Enforcement Committee meeting agenda, but it seems like whatever that conversation is, it sounds like it could be a great newsletter article to be able to, or the social media posts, because I feel like in terms of, I know that outreach and education talked about how we utilize social media, but I feel like it would be a way to be able to educate folks, and again, we all are here for the public protection as we license the practice of psychology, but I do think that we also have to make sure that we communicate what we know, and so that it's transparent. So giving you guys an assignment, Ms. Akwebudu.
And I believe I speak for Ms. Akwebudu, our chair of the Enforcement Committee, which I'm also a member of, that we will agendize this, but we've been working on the disciplinary guidelines for a substantially long period of time. We need to finish that process first, and there's other intervening issues. So it might not be at the next meeting we discuss it, but we'll discuss it as soon as possible. Is that fair? Okay. Just defending our turf. So now there's time for public comment. Again, please limit your comments to 5 minutes or less. Please try not to repeat any speaker that came before you. And further, please do not mention the specific names of licensees for fear of prejudicing any kind of disciplinary proceedings against them. Thank you.
I'm Helen Lynn. This is Santa Barbara, California. Mother told forensic psychologist, I won't mention his name, her concerns that father had mental issues and was abusive to their sons. So the forensic psychologist labeled this case a parental alienation case and recommended custody to father, Nicholas Holzer. Holzer killed his sons, the grandparents, and the family dog. Here's a second case, San Bernardino County. Katie Tagle, accompanied by police with evidence, pleaded with judges to issue a protective order because father threatened to kill baby. Using parental alienation, the judge ordered custody be turned over immediately to father, Steve Garcia, who killed 10-month-old baby Wyatt. Now, I know you mentioned you don't have any power over the courts, but there you are, the Board of Psychology, at every legislation that we try to protect children. There you are opposing us. I want you to own that. All of you on the Board of Psychology, the California Board of Psychology. You're responsible for these deaths of children, the grandparents, the family dog, and baby Wyatt. These are 2 of 2 million parental alienation cases. The Family Law Quarterly found custody evaluators and minors attorneys do not consider abuse as a factor. Instead, cite parental alienation as a major determination in recommending custody to abusive fathers. And so that's the end of my comment, but I was wondering if you had any idea if the Board of Psychology could do anything to get divorce courts to stop labeling abuse cases, parental alienation cases.
My sense is that might be something that's better addressed through the California Judicial Council. That's kind of your
They oppose all of these laws when we ask them to.
I also want to
consider
add, there may have been times when there were statutes you were in favor of in terms of protecting children, but I don't think that we as a rule oppose laws that protect children. I don't think that's
Yes, you
consistent.
do. Yes, you do. Yes, you absolutely do.
Can you give me an example?
Those 2 cases I mentioned, those were 2 of 2 million.
No, I'm
All
saying
abuse
of
cases,
statutes.
cases are labeled parental alienation cases.
Okay.
And also, you should have something to do with, I think, custody evaluators who recommend custody to abusive fathers, basically.
If a custody evaluator is our licensee or registrant, we can entertain a complaint against them. Otherwise, we have no jurisdiction over them.
I think, too, there's a problem because I believe parental alienation is part of the evidentiary code.
I don't know one way or the other.
But I was hoping that somebody on the California Psychology Board would care about children. Protecting children should be top precedent for the California Board of Psychology and for the, for the courts, which I know you say you don't have anything to do with the courts. But I was hoping if you had any influence over protecting children to make that top precedent. Thank you.
Thank you.
Hello again. Kathleen Russell, Center for Judicial Excellence. I just really want to thank Sandra for her responsiveness in setting forth this policy, this change in policy when I brought this to the board or to the staff last summer, that there was this restriction around investigating child custody psychologists if you didn't have signed consent forms from all parties, and obviously in high conflict divorces, especially one where a custody evaluation switched custody, that's not going to be forthcoming. So that really was a chilling effect that the board had. That was the process that was shutting out all of these families who are losing custody of their children to physically violent and sexually abusive parents. So I really am pleased by the responsiveness of this board. Our organization has been going to the California Judicial Council for 2.5 years, and we've never had this sort of care and concern communicated back to us about what really is a crisis. And we understand that you have a limited jurisdiction, that you can't get involved in court issues or, as you described, camps or other things. But what I think, and we understand this is all new to this board, so there's a bit of an education process here. But what you do need to understand is that these reunification camps, which are done through court order, are being run by your licensed PhD psychologists. So these individuals are your jurisdiction. You have pending complaints for over 2 years about these programs, which are conducted in hotel rooms by PhD psychologists in California that are threatening children who are already at-risk youth, who are suicidal, and they're threatening them that they're not allowed to talk about the past, that they're not allowed to see the parent that's been raising them, that they're most bonded with, And you as psychologists know the importance of attachment and bonding. These children are teenagers and they're being ripped out of their lives. They're told they can't talk to their friends or their boyfriend or girlfriend for 90 days from the time they get home. And many of these kids are describing in horrifying detail what's going on in these camps that are being done at very high profit for these PhD psychologists. And these are not psychologists who are shrinking in the shadows. One psychologist, her 2 camps were 2 of the largest sponsors of the AFCC National Conference this year. So this is being done on a national level, very openly. It was in the Washington Post magazine. So this is something that very much falls under the purview of this body. And so I appreciate all the attention and the agenda item dealing with your new procedure around this. I did also want to mention, because I actually saw one of your letters recently asking for more information from a complainant, and I know there was discussion earlier trying to understand what some of that insufficient evidence might be. And just to mention, I really appreciate that you have this, whether they have custody or not, the investigation will proceed, because that is how this is often done, is that the court will switch custody and then the complainant who's been harmed by the psychologist has no standing. But in this particular case, one of the items requested by your board was proof of legal custody of the child. And so this parent said, I don't have that because custody was taken away from me. And I appreciate that you say you'll continue with the investigation, but if she's not able to provide that document, is she going to be kicked out as insufficient evidence? So I guess that's one of those items that I said maybe you should go back to a previous legal document from years ago when you did have legal custody. But there was a gray area of confusion for this particular complainant because she doesn't currently have custody, but she did at one time. But through the, the problem with the psychologist, she lost the custody. So that's one of those gray area issues. I would also love to hear from Ms. Monterrubio the timeline for each phase of this investigation. I appreciate the thoroughness of this outline and all the different steps that go on. And I know we've had phone conversations about the DOI and their investigation, and I understand that can take many months. So I would like to propose to this body that if it be possible for you to create a policy to expedite complaints dealing with child safety, because these are children's lives, and sometimes the complainant comes in and the child's 8 years old or 10 years old, and these are years of abuse that they're potentially, yes? Okay. Yeah, I just also would say that I see on this memo about your child custody evaluation complaints, the board is a consumer protection agency and is committed to protecting consumers of California from potentially harmful licensees and practices. I think you should reword that, because what we're seeing, and you'll hear from people today, is it's California psychologists who are harming residents of other states as well. So that this needs to be focused on the California psychologists, not the consumers in California, because California psychologists are now shipping children in from other states to harm them.
Thank you very much.
Thank you.
Hello, my name is Radhika Pochampally. I came from Mississippi. Why am I here? I am a victim of your psychologist. Back in January 2006, a court in New Orleans has ordered to return my children to their abusive father, who has been demonstrated to be found to be violent, and he has a pending DV case to be adjudicated very soon. How did the court do that? They used the concepts that your psychologists have perpetuated. Because I can't name names, I will not. But I'm sure you understand the pain I'm going through because psychologists from California have influenced a court in New Orleans to take my children away when they're 16 and 14 now. 16 and 13, almost 14 now, to be put in their abusive father's care and have no contact with me. Why? Did anybody allege abuse? Did I do anything wrong? No. Just because a court decided, and some psychologists had affirmed, that I have alienated my children against their abusive father. And then, a few months, they were put in reunification therapy, all dictated by psychologists from California, principles dictated by psychologists from California. And now, that psychologist writes a report to the court, sends a report saying my children don't want to see me. Somebody on this board explained to me how anybody can sit there and tell me that as this board member of further psychology, science, if it is, that always advocates bonding and children's welfare and the necessity of children to bond with both parents, feel that it's okay to be turning around and say if a psychologist recommends that children don't want to go see their mother now, it's okay. So now going back to who I am. I am a PhD. I'm a cancer biologist and a professor at a medical school. Now, as a scientist myself, I find it outrageous that a concept that is not peer-reviewed and peers reject. Every research I've done on PAS shows that most peers reject that concept. Still continues to perpetuate. And as a regulator or the regulatory or gatekeeping board that's sitting around here, I believe the onus is on you to make sure that the science that goes through your doors should be real, that's honored. I can't, as a scientist myself, and we don't have any licenses, I'm not regulated by a licensing board. However, my peers regulate my science. Every day when I publish my paper, I want it to be peer-reviewed and accepted. Without that, my career is doomed. And how is that psychologists don't have that, they are not answerable to that? How is that somebody can perpetuate a junk science, make money over kids, and that's okay? Going back to a comment made earlier, that it's not, reunification camps are not under your jurisdiction. This is akin to a story where if an oncologist that's licensed by the board, state board, takes all the miracle drugs that have been perpetuated or that you see on Facebook pages and shared everywhere, or you eat this fruit, your cancer will be cured. If this oncologist takes his patient to a hotel instead of the hospital that he's appointed by, and gives that patient this particular drug to using his licensing power, does that mean that the medical board does not have a right to stop him and punish him for not violating the basic ethics and rules of the licensure per se?
Can I just comment on that? Because that's exactly what I was saying. Just what you just said. We don't have any control over these camps, but if a psychologist, if there's a complaint against a psychologist who's functioning in this way that is unethical or whatever else, we absolutely can pursue that. So that's exactly what I said. That's why I said, if there's a complaint against the psychologist, we pursue it. Yes.
Right, but if there have been complaints filed, and we know several have been filed, and I was part of some of those, directly or indirectly, when does it come to a stage where you say, enough is enough? We've had 4 complaints, we have 3 complaints.
I just had one quick question. Have you filed a complaint against this psychologist?
I did not directly, but I've been part of it. We are working together. I have not been directly affected by these psychologists, but the psychologists are working with the psychologists that are on my case. So that's why I'm here, to address the roots of this poisonous, venomous thing that's been spreading all over the country and all over the world.
Thank you very much.
But I've left some information here, including my testimony, for you to review, and maybe if you have any questions, I'll be happy to answer.
Okay, you can leave that material with Ms. Burns. Thank you very much. And the next speaker, ma'am.
Kimberly Swady again. So I'm going to challenge you to rethink as I said, your entire paradigm, because at the end of the day, justice cannot be for sale. This entire idea that's been perpetrated by both the psychological community and the judicial or divorce industry is that everything is for sale. Now, understand, I'm not a bleeding heart liberal. I'm actually a capitalist libertarian. I believe in free markets. I do not believe justice falls under the purview of free markets. It cannot be for sale. And this multi-billion-dollar industry that's been created by corrupt divorce lawyers, judges in cahoots with them, private judges, and the psychological community is an obscenity. You have no control over the courts, I recognize that. But I'm working, and I will continue to work for the rest of my life to put the judicial community back in order and return these matters of divorce and child custody to a jury system, as we have a right in all types of other areas to have a jury system, including in criminal matters. That's the problem of the judicial system gone awry. Let me talk about the psychological community jumping on board with these crazy lawyers and judges to get in with this money-making nonsense instead of doing the proper thing that they should do. Now, I have a therapist that I use. She does not participate in divorce law. She contracts with individual patients, working privately with them in cooperation to, as she says, be the best version of themselves, to show up and be present in their lives. And whenever the two of them together decide that treatment is done, it's done. And if it's not, it's not. And that's private, and it's between them. But she doesn't want to be involved with this type of nonsense. And I've spoken to other reputable psychologists that say the same thing. So the problem with the divorce industry and the psychological industry is they are attracting the worst of both of these two professions. And at a place where we need more than ever integrity, authenticity, we don't have it. In the protection of children, they are our resource for the future. They are everything. And yet we have the worst of the legal community and the worst of the psychological community benefiting from their pain and suffering. This is just a recipe for disaster. So yes, I would be insisting that not only we do return this to a jury system, but that psychologists get the heck out of the divorce industry and this whole thing become again about justice. Not that there's not a place for therapists, as I've said. I use one myself and have found her very helpful in weathering this trying time of the last 4 years since my separation. I value her very greatly, precisely because she's not part of this broken system. We've heard today about camps. For anybody here, does the word camp envision anything good? Because when I think about camps, I think about Nazi Germany, I think about the Japanese internment, I think about the Native Americans on reservation. I think of all kinds of not good things. Now you could say, oh, it's like summer camp. No, no one thinks that. It's not like the community service camp that I just sent my daughter off to in Colorado so that she can work with wolves and get back to the community and also have some fun, or the one she's going to go to in Florida, or the one my other daughter's going to go to in Beijing working in an orphanage. That's not the kind of camps they are. Those are voluntary, and those are to expand their mind and their experiences, and they come back transformed. These camps are mind control. So you might want to think about the psychologists involved in running these things and recommending these things. You are not innocent here. The word camp does not have a good connotation, and we all know it. It's scary. It's mind control. We're going to talk to the form letter rejection. I've seen a number of these form letters. I commend you that you're admitting that you don't know what letters look like that are going out to the public. I've seen a number of them. They're appalling, they're dismissive, and they need to be reworked. They need to be reworked, and look at them. Just look at them. And I'm glad you admitted here that you haven't looked at them, because you do. And they can be greatly improved as to their content, and that should be part and parcel of all of this. You ask what types of psychologist reports are, there was a question about psychologist complaints and the types of things that they're ignoring. In my experience, because I've spoken to a number of women who all had the same psychologist that I did, they're ignoring domestic violence convictions. Not allegations, conviction. Something about the Terrorist Act, terrorist threats. I guess if you're bad enough at being violent, there's some terrorism is involved. These are being ignored. Spontaneous children's statements about being abused are being ignored. This, I don't know how you find that a psychologist. Okay, so these are the types of things that are not being acknowledged or addressed in these custody evaluations, and these complaints are being dismissed as groundless. This is just patently absurd. And the last of all, multiple complaints about the same person show a pattern of behavior. One of the ethical violations talks about a repeated pattern of behavior by a psychologist. But I was informed that the Board of Psychology does not accept joint complaints. So there's a contradiction here. If one of the ethical violations is that there's a pattern of behavior by a particular
I'm
individual,
going to cut you off. Thank you for your
then
thought-provoking
you do need to look
comments.
at joint complaints and repetitive allegations by multiple people. Thank you so much for your time.
Thank you very much.
Catherine Campbell, again. Board members and Ms. Monterrubio, I just want to thank you for adding this to the discussion as a line item. Ms. Monterrubio has already heard from me directly, and I appreciate that time, because it just shows me that you as a board and as a process committee want to ensure that this process is actually working. And based on my situation and other situations I am aware of, it's not working. And I appreciate that you want it to be working and that you have guidelines and you have procedure. But we have to figure out why it's not working if we have all of this. I was told I shouldn't make the complaint because I would lose custody. So there's a problem in itself. First off, sadly, in California, we have found that if you have music playing, if you report abuse of your spouse, you have an 85% chance of losing custody to that person. And even though these things take place in family court, the psychologists write the recommendations, and those are basically rubber stamped because they write how many hours they've spent. They write, how in-depth they've gone, but they ignore certain reports. They are biased. Mine have had false statements in them, and then they say they'll correct them and they never do. I mean, in mine, they even said that the child denied the abuse, which was never said. They're unethical, the way they're presented to the court, and it is very disturbing what is happening because they know they have the control because they haven't been disciplined. So they can go in and say these things. They can come to you and say, you can only have custody if you tell the children the abuse never happened. You can have custody when you tell the children they are safe with their abuser, and you have to promise to never report him again. So these are the things the psychologists are writing, and then you're supposed to make a complaint against them. So I've had psychologists who are not my psychologists report my condition because it's another form of parent alienation syndrome. And they use this as an excuse, and this has to stop. Because what is happening, children are losing custody, and it's because the evaluators who are licensed psychologists are recommending this. And they are getting, and it is the person who they're recommending, tens of thousands of dollars they have charged that they can use this. And so for instance, I hear you very clearly that you can only work on complaints. All right, so you're threatened not to complain or you'll lose custody. And so I went to the people who, in my case, never reported as a mandate reporter. And I said, you can lose your license over not reporting. And immediately they accused me of a form of parental alienation to discredit me so I would never be believed. And when you have this process of discrediting the truth, ignoring the truth, and turning a blind eye to the truth, you are going to have your ACE studies go up, you're having child suicides go up. The CDC came out to Palo Alto because they're saying, why are these going up? Well, I can tell you is because when you are told not to report abuse and not to do anything because you'll lose custody or you'll hurt your child, we are faced with knowing, I personally know that a psychologist that I have used, and I have used multiple psychologists, my family has spent $2 million on professionals over 12 years, and we are in a system that allows the abuser to continue the abuse, and they do it through using professionals. And these professionals are licensed. So when I'm sitting here in fear of not being able to report, and because I know other people have reported on these individuals, and they have had very clear violations. They legally have done wrong in these cases, and they are not being sanctioned. They're not losing their license. In fact, one of them just got an award. It is called, from the California Psychology Association, the 2017 Distinguished Contributor of Psychology Award. And these have multiple reports. Now, I'm here because you need to know, have I hit 5 minutes? Okay, so I'm here because this needs to be awareness to you all, that this actually is happening, and we need to change that. We need to be authentic, and we need to do better. Because it doesn't, when you know better, you do better isn't actually true. It's a choice and an action. And I would like this board to be authentic with, even though we have these procedures, why are these things still happening? Thank you for your time.
I definitely just say, as we hear more comments, even saying what an award people have, I think that's an unfair thing too. So I think that's referring somebody. So I don't think that if anyone else is coming before, we shouldn't do that, because I don't want us to be in a place where it taints our process.
It's just a misconception of what's happening with these.
No, I wasn't talking about, saying in terms of people referring to an award honoree or something, in terms of not saying their name.
Is referring to their identity.
It's giving their identity, so let's not do that, because that's what the president just did.
My apologies, I tried so hard not to give identities.
And I appreciate that.
Okay, thank you.
Thank you very much.
And we could leave that out of the minutes, that particular.
Yeah.
Would the board like a copy of things that I can give to someone, and they can redact the name so you can see that one person has had complaints? So I'll give you a copy. Feel free to redact as much as you need to, and so everyone can get a copy of that, and I'd appreciate that.
Thank you. I think there was a fifth person that wanted to speak. Are there any?
Hi, I'm still Sandra Ross, and I'll go ahead, I still haven't figured this out either. There we go. Oh, automatic. So I'm still Sandra Ross, and I heard the word standard of care. I'm not sure if that's what the board oversees, what that is. I am personally aware of litigants that go through several of these 730 child custody evaluations, and each one is different. Something to do with testing and examination where there's inter-rater reliability. I would be willing to bet that 10 different psychologists would come up with a different outcome on some of these examinations. I don't know if the board oversees training or education or what the standard of care is to actually look at, but that's an area, it's all over the map. And a lot of times, unfortunately, it comes back to how much can you afford to have your case investigated. Again, if that's not part of your role, I apologize, but I'm very grateful that you're here actually listening to us, so thank you.
Thank you very much.
Comment about the fear about making a complaint. Well, two comments actually I have, because I feel like what we heard, which was great public testimony, thank you everyone that shared your comments. Most of the folks that spoke, I think that you asked Ms. Bernal, have you submitted a complaint? They have not done the complaint themselves. And so I think that is interesting, but then the notion about the fear of submitting a complaint. And so, Ms. Monterrubio, I know that in other situations outside of the child custody realm, people could also feel afraid to make a complaint against their psychologist. In terms of that kind of protection or the process by which people come to the board, can you describe that? Because in terms of kind of alleviating that fear and what that looks like, because I feel like the way I understood the process is that some of that stuff is held in confidence at some level. But could you explain that to me and to the board?
Right. When you file a complaint, we try to not share the information, but eventually if it goes to the Office of the Attorney General, that information can become discoverable. So you cannot be completely anonymous when filing a complaint. You may need to be a witness, of course, at this particular hearing. I'm not quite sure if the statement that was made about fear was fear from the board or fear from another outside entity. But when filing a complaint with us, again, we investigate every single complaint, but we cannot keep your information confidential if it were to go to the Attorney General's office.
Thank you.
I did want to say we very much appreciated the public testimony today. We know this is a very difficult issue that impacts families. We do take it very seriously, and we appreciate very much the information you've shared with us and the observations that you've made. And thank you, Ms. Monterrubio, for helping to better explain the process.
Sure.
I just wanted to make the staff comment that we will provide you with the information once it's redacted, and that any comments submitted previously to our staff was also redacted and provided to those board members as requested by those people.
Typically, this would be the point at which we take a lunch break, but it won't be today, because we have the Policy and Advocacy Committee report, and due to a conflict that could not be avoided, our chair is not going to be with us later this afternoon, so we wanted to make sure to give her the opportunity to give her report so we have full consideration of it today.
Okay, thank you. The report will be happening now. That's it. Can we move to tab number 12, please? And in the absence of Mr. Glass-Steagall, I just want to acknowledge his hard work. Thank you, Mr. Glass-Steagall, for all of the work you and Ms. Burns and Mr. Connor have worked on in preparing all the materials for the Policy and Advocacy Committee. Dr. Erickson and I met in April. And so please, if I miss anything throughout the report, Dr. Erickson, please jump in and let me know. But we're going to start with the first agenda item, 12A1. And that is the legislative update. regarding the two items, the omnibus proposal and AB 89. So Ms. Burns, if you could walk us through the omnibus proposal. As you might remember, last year, or was it this year, in February, Ms. Burns explained to us that the omnibus proposal process allows us to be able to do a little bit of tweaks to our codes, our statutes, rather. So please go right ahead.
Absolutely. So as the chair of the committee explained, omnibus proposals, you get to do clarifying, usually non-controversial changes to your statutory provisions. This year, at the February and then also the April board meeting, we proposed the psychological assistant fee change of who pays the psychological assistant fee, and then also added in April the delinquency fee, which was rather artificially low and out of sync with other boards and what they do. So both of those provisions were adopted at the April board meeting. They were submitted to the Senate Business Professions and Economic Development Committee, and that's who authors the bill and pushes it forward. So those items were sent along to the committee. They will be incorporating them into SB 547. They have not been incorporated as of yet, which is why you don't have any text yet. So we heard from the committee that it should be in the next couple weeks, and they expect a hearing, the last hearing in July before the legislature goes on recess. So probably in the next couple of weeks, we'll have some text, and all future updates on the omnibus will come as part of the SB 547 update. So that way it'll be part of the legislation.
Thank you, Ms. Burns. There's no action now, just in terms of information. Is there any comments from board members on this item? Seeing none, hearing none, I'll take the next one and then we'll open it up to public comment for legislative updates in general. The next item is AB 89, and as you will recall, I'll do a tee up and then I'll pass it over to Ms. Burns, actually to Dr. Phillips first, and then Ms. Burns. This is the Suicide Assessment and Intervention Coursework and Training Requirements Bill. You might remember last year we did a lot of work on this, actually the last 2.5 years, probably done a lot of work on this. It went to the Assemblyman Levine's office, and in January it was introduced as a bill, AB 89, and this would mandate continuing ed coursework in suicide prevention, assessment, and training. And we also then took a position at our February board meeting where we took an opposed position of this bill. And back to earlier comments about the minutes, the notion of the opposition meeting that Dr. Horn raised, that we did work really closely with the author's office, and there were some folks that were in opposition to this bill. And I know that Ms. Burns and Mr. Glassbeagle and maybe even Ms. Sorek were a part of meetings with the offices and the part of that opposition group. So in your packet, you got a memo that was dated June 1st. Today, you received a hand-carried packet, because if you read through your memo, you saw that there was a hearing that was slated for June the 5th. That committee hearing, or that committee meeting did happen, and Dr. Phillips represented the board and spoke on behalf of our support for AB 89. And so, I'll pass it off to him first, or do you want to give a fuller overview first?
No, just to clarify, we didn't take an oppose on this bill. We took an oppose on 2198, and that we're sponsors of the bill.
No, I didn't didn't mean to say oppose. I said the opposition team met with them.
Okay.
But no, we took, I'm sorry, let me correct myself. We supported this bill. This was one of the bills that we did. I'm sorry.
No worries. I just thought I'd catch it then.
Thank you very much.
No worries.
One of the other things that is not mandated continuing ed alone is verification of students' experience.
Exactly.
Or training and graduate program or continuing ed.
So this will be a one-time continuing education requirement for those that didn't get it previously, and a initial application requirement.
Right.
For
So it
all
is
of
mandated, but the verification of it would actually suffice for the satisfaction of the requirement. And then for all of those that are new applicants, they would show this as a mandated requirement.
And just to add one further thing, to the extent that licensees are listening, and should they need to take a 6-hour continuing education class in order to satisfy this requirement, should the bill be passed, that will count, they can count that toward what is currently now 36 hours of continuing education, which goes toward continuing professional development. So we're trying as little as possible to, or as much as possible, not to unnecessarily impose a burden on licensees, while we also give ourselves some peace of mind that everyone has received at least a minimal amount of training in this area.
And I will just also add, to muddy the water in any way, also the comment in our last board meeting in April, the question was, how would people demonstrate that? And as we know through the CE audit process, that's where it would actually happen. So people aren't submitting something if this were to pass January 1st. So do we cover everything, Ms. Burns, in terms of the background and overview?
And that applicants would submit it as part of their initial application for licensure.
Exactly. And if you could tell us 1 second about how everything went on June 5th.
Okay. Ultimately, we were very well received by the committee. They asked some thought-provoking questions in terms of why we had picked a particular number of hours, how the mechanism would work. So there was some discussion of that. There was also spirited opposition from the California Psychological Association. Ultimately, we received a 9-0 vote. When we left the room, I think it was 7 in favor, 0 against, and 1 abstaining. Ultimately, the abstaining member ended up voting for it. There were 2 healthcare providers on that panel. One was Dr. Hernandez, who is an optometrist, and then Dr. Pan, who is a pediatrician. And they were the source of probably the most interesting questions in that regard. So we thought it was well received. The feedback we got from the committee through their staff was that they thought it was refreshing to see a board, particularly licensees of a board, advocate on behalf of doing something that maybe isn't being done quite as well as it could be done, and that they thought that showed a lot of, that we were really being introspective about what our obligation to the public was. And in my mind, I thought to myself, well, of course we're introspective. We're the Board of Psychology. But it was a very nice compliment to get back, and so the next step, I think, would be it goes to the floor of the Senate. Or no, it goes to appropriations. We aren't anticipating any difficulties in appropriation because there really is no financial burden to the bill.
There's a very minor and absorbable cost for the bill, and we do anticipate to have the hearing on June 26th.
Dr. Horn?
So,
Thank you, Dr. Phillips.
first of all, I'm glad this is going through and all that kind of stuff, but there is this one thing, I keep reading it, and I don't think it really conveys what we want to convey. And this is just in the background part. Due to the significant variances in the current educational and training requirements, there should be a one-time minimal requirement, et cetera, et cetera. We are actually allowing for those significant variances because we're saying if you've had this in an applied setting, if you've had this as part of your training, all these kinds of things, and you can demonstrate that, then you do not have to take this one-time course. So I want us to maybe think about it differently if there's anything we need to do going forward. We're doing this because we just want to make sure everybody has at least some exposure, some minimal exposure to this training, because this is certainly not enough training. And probably a lot of those variances, if they've gotten them in applied settings, will be more than any 6-hour course would be. So I think we do want to just say that all of our licensees, if they haven't gotten this in some way, we're at least saying that they should have this exposure that kind of standardizes it a little bit. But I think when we talk about due to the variance, I don't want to belabor this point, but we're allowing that variance to count. And so that is not why we're doing it, in my mind. And I don't want that to be the impression that's left with the legislature.
And Ms. Burns may correct me if I'm wrong, but part of what they're reflecting on, I think, relating to when they say significant variance was when we gathered the data, some programs were saying they spent up to 51 hours, I believe it was, in doing training, and some people said they were doing as little as six hours.
I know
And then
that, but
some programs weren't doing any at all. So there's a significant variance, but we're not, you're right, we're not correcting the significant variance.
that's exactly right.
We're creating like a floor.
Right.
Right.
And only for those people who haven't been exposed, either 6 hours or 51 hours or 151 hours.
Interestingly, and I believe, Dr. Horn, you've had the same experience. When I've talked to my more senior colleagues about this, who have maybe been practicing for 10 or more years, and some of them practicing 30 or 40 years, almost universally, what I've heard back is not that they were concerned about having to take more training, but they actually welcomed the opportunity to take more training. So that kind of, we haven't had the same, we haven't had quite the same level of discontent that we might have seen with other initiatives we've taken in the past. In fact, it's been pretty quiet.
No, I agree with you that, I mean, my colleagues I've talked to are absolutely fine with it. But again, I'm concerned about this impression. I don't want us to leave this impression that we're correcting a significant variance. No, we're saying that variance is fine. We just want to make sure anybody who's been out there a while and maybe didn't get this exposure, we just want them to be exposed. And we're doing that because this is a significant problem in California, not because we have significant variances in our training. I mean,
So, point taken, and I think that what you're saying is that language matters, and so I think that maybe we can direct staff to capture the spirit of this conversation, because I do think that, I think you could say it and mean significant variances based upon the way that Dr. Phillips just described it, but I could see how you would reject that notion also, right? So the idea was, and as a part of a member of those committee meetings, that was the issue, that it was not all the same, and we wanted to make it more across the board. So if there's a way to capture that in a way that would be a little bit more palatable,
Why don't I work with both of you, since
that would be great.
the concern with the language has been an ongoing thing for us, and I understand that, and I appreciate that, because language matters. And so maybe I can work with both of you on how we want to better explain our reasonings and then also terminology.
And I would say, and I would say also that Dr. Erickson and I are working on a newsletter article that maybe some of that language could be lifted over to that, because I think that's also what we've wanted to communicate and be transparent about, is to ensure that we capture why, as a board, we discovered this. And I will just say, it's refreshing to hear your report back from the June 5th meeting, because part of what we talked about at the time as well was us being in a leadership role on this, knowing that other folks and other boards had not taken that lead. And so, Dr. Harlem, if you're listening, I know that we did have that conversation about leadership and taking that role, so, in that licensing committee meetings.
and that's why we're doing it. Not because of the significant variances, but because we are taking a leadership role, because this is an important problem in California, and we want to make sure that at least everybody's been exposed.
And we wanted to get a
That's why.
baseline. We wanted to get a little bit, we wanted to make sure that at least there was a minimum across the board. So,
Yeah.
and I think that's where that variance piece comes in, but Dr. Erickson and I will solve that issue, and we'll work with you, Dr. Horn, and make sure that language, and we'll work with staff on that. But that is the essence of the conversation. And thank you for representing us so well, Dr. Phillips. So as was stated in the overview, we had already, we've made our position known on this, and we've continued to be a part of it, so there's no action at this time. So for these two matters, is there any public comment? Dr. Jolinder Crow, please come forward.
Dr. Jolinder Crow, I'm the Chief Executive Officer of the California Psychological Association, and I just want to make a couple of comments, partly reflecting what happened in the June 5th hearing, and in some ways sort of piggybacking what all of you are saying. I have understood, and the California Psychological Association is in opposition of this bill, as you know, and we continue to be in strong opposition of this bill. we have been concerned all along about the potential for leaving the impression that psychologists are not well-trained, period. And I would urge the board, when you write this article, if you are looking at publishing something, that you do try and find a way of capturing this in a way that does not perpetuate that impression. We were after the hearing on June 5th, and I hesitated to raise it today, but I think in light of your discussion, I did want to just make a couple of comments. We were left after the June 5th hearing with a lot of concern about the impressions, the lasting impressions that were left with the Senate committee. Your feedback from the staff, I'm sure, was from one perspective. The feedback we received from staff was a little concerning to us, and we are concerned that they were left with the impression that psychologists are not well trained in general, and that certainly psychologists are not trained in this area. In fact, there was a reference to an article that stated that only 40% of psychologists get training in this, and that is one of the last things they heard at that hearing. We do not believe that that is true. I know the article that was referenced. It was one article. Your own data dispute that kind of a conclusion, your own data. So I would really urge, I understand, I think, the reasons that you are saying that you decided to sponsor this bill, but we remain really concerned about the impressions that this is giving about the profession at large and the kind of training that psychologists get, even though you have stated many times that psychologists are indeed the most highly trained mental health professionals. We believe that, you believe that, and I would just urge you and ask you to be very careful about the language that you are using in your support and defense of this bill, because we are risking, I think, a misimpression that I don't believe this board intends. And I never have thought that you intended that, but have always been concerned that that was a risk in these various ways and all this language that has been used to support this bill. So I hope we can, the bill passed out of both committees. It may get to the governor's desk, probably will get to the governor's desk. We remain opposed to the bill. We have our own reasons for being opposed to the bill. And I would hope that you know, when you move forward in any, and if there are opportunities for the staff or board members to clarify what may have been some misimpressions, I hope you will take advantage of that. Because we don't want to, we hope, and of course we don't want to leave the impression that psychology as a discipline is deficient in training psychologists, when your own surveys, again, said that 97% of all the respondents that you have said they provide training in this area. So I just wanted to comment. I appreciate your reasoning. I appreciate the fact that you're having success with this bill, and I appreciate your belief that you are providing leadership in this area. But I would ask you again to just watch for that other, perhaps unintended consequence that may come from all of this.
Go right ahead.
I very much appreciate you expressing your concern. I do think there's a way that narratives can get built around certain events that can either give them a negative cast or a positive cast, and that's being respectful of your impression when you left the hearing. I think we're showing leadership in consumer protection, which is ultimately our obligation to protect consumers I do believe that psychologists are among the best trained mental health clinicians. I think there's other occupational groups that might make an argument that they're equally well-trained, as psychiatrists, for example. But I think we do bring a really unique skill set to this area. And this is just my personal opinion. This is not the opinion of the board as to the next statement I'm going to make. I don't think psychology is doing as good a job in this area as it could. That doesn't mean that the rest of the training is terrible. In fact, I think the rest of the training on the large part is wonderful. But I think this is an overlooked area, and I think it's important that we bring it to the attention of our licensees and indirectly to the attention of training programs and training facilities. So that's where I'm coming from. I do think we're showing positive leadership, but I certainly can appreciate that you're concerned about what the impact may be on the profession.
Thank you.
Thank you, Dr. Linda Crow. Is there any other comments? I do just want to say, as we move out on this, I know that the other comment that in being a part of these conversations over these 2.5 years, I will just say that the other issue was the survey evaluated or surveyed current programs, and we also have licensees that have been licensees for a period beyond the time. So that was also, that notion about variance, which I get it, the language should change, but I think that was also part of that conversation. So Dr. Erickson and I, we have a tall task, and we appreciate the public comment, and we will incorporate the spirit that I think, and we'll share with you, Dr. Horn and Dr. Phillips, before we send it to the staff for inclusion in the newsletter. Okay, so that concludes this section of the legislative updates on those items. Let's move to the tab for B, please. And the first section under 12B1 is the recommendations for active positions on bills. So we have been looking and watching several bills since the session began, and these are for that staff now want us to take a position. So let's start with 12B. I love saying all the numbers. 12B1A, and that is AB 700, Assemblymember Jones Sawyer's bill on substance use disorder counseling.
Ready?
Are you there? We'll wait.
Yeah, you want me to wait a minute?
No, it's on a hand carry. It's in the book.
No, it's already in the notebook. Yeah.
She's just organized.
Should be the first one behind 12B1.
1A, yeah.
All right. So this bill would require any person who engages in the practice of substance use disorder counseling to be certified by or registered with a certifying organization unless specifically exempted. This organization in the state would be Department of Healthcare Services. Previously, the bill had said psychologist. The concern that was raised by staff was that it named specifically psychologist and not those accruing hours for supervision for licensure as a psychologist. So those that were psychological assistants and working towards licensure were not also provided the exemption in this bill. However, those amendments made on May 30th have also included those people, so it now has a person who is gaining supervised experience towards licensure as a psychologist are now also exempted. So those that are psychological assistants or psychology interns and trainees, those would also be exempted under this as well. So we no longer have those concerns after the May 30 amendments, so it no longer needs a position. So this is just for informational purposes at this point.
And I know you put on here, unless the board felt differently. So
Yes, so
we
unless
wanted
the
to
board looked at it and
discuss
had other problems.
Yeah, so we wanted to bring this to the board's attention in case, folks had a difference of opinion than what staff is recommending currently. Okay, so we'll go ahead and take these four before we open it to public comment. The next item, 12B, 1B, AB 1456. And
hand carry.
yes. So it's in your book, but there's also a hand carry that has been updated, because some updates happened, some amendments happened on June the 5th. So we'll wait for you to grab those if you haven't. As people are looking for them, why don't you go ahead and give the overview, Ms. Williams?
Absolutely. So this bill deals with exempt settings. This one is that the law prohibits licensure requirements for professional personnel to be less than those for other professional personnel working in health facilities under private ownership. So those working in exempt settings, as in the state with corrections, Department of Public Health, or Department of State Hospitals, you can't have lower standards than you would for private settings unless otherwise exempted. Currently, we do have some exemptions, and right now, they are usually, for the most part, 5 years. Right now, CDCR and Department of State Hospitals and CDPH had a 3-year exemption with some extenders to that. This bill at first would have made it 5 years, and then when they were trying to get through one of the health committees, the committee said it should all just be 1, but they weren't taking into account that social workers, clinical counselors, the exemption for them was different than the exemption for psychologists. So we talked to our committee. We also talked to the author to raise the technical concerns that if you changed this bill to only extend it by 1 extra year, since it's 6 years for social workers and clinical counselors, if you did that, that bill then allowed these groups that are working at CDCR, CDPH facilities, or state hospitals to have 6 years instead of 5, and that would create a new inconsistency in the law. So if the point was to make it all consistent and all at 5 years, then we had a technical concern. We brought those up to the author. The author was understanding. They talked to the previous committee. The committee was okay with that as well. So they went ahead and made those amendments on June 5th. So now this bill would have all 5 years. So the exemption would be 5 years until you have to get licensure with the Board of Psychology. So if you're working in a correctional facility, then you can work there up to 5 years while you're accruing your experience, and then you would have to get licensure. So this makes the 5-year consistent across, which also matches up with where Pathways is going with the psychological assistance. So that way, it would be less confusing for the public and for the employers. Everyone would be similarly on the 5-year exemption.
And initially, at the May meeting of the Policy and Advocacy Committee, we had discussed and made the recommendation, we had approved a motion to make the recommendation to the full board to oppose unless amended. And so, and now that the changes have happened, the staff recommendation is to support AB 1456.
Yes.
Any questions or comments? And more importantly, Dr. Horn, because it came up in the conversation about the work on Pathways Licensing Committee, so that would be really in line with the work that you all are doing in the committee. Would someone like to make a motion to adopt the support position?
I'll make a motion that we change our position to support.
Actually, just to take a support, because we
Take
never
a support
did it as
position.
a board.
Oh, okay. Take a support position on this now that it has been amended.
Second.
Any other board discussion about supporting AB 1456? Any public comment about the motion to support AB 1456? Hearing none, he's last. Go slow with the voting process. Please.
Akwe-Badu. Oh, do you have a question?
Yes, I was,
Go ahead.
okay, no, I was just going to say, when the language, so we're looking at restructuring and reframing the language in this bill to make sure that, as the comments have been made, to make sure that it retains the notion that psychologists are well-trained and all of this.
No, this is the professional, the 1456.
Yeah, but the years.
Just changing the years. And initially, the first version of the bill, before, when the Policy and Advocacy Committee reviewed it, it was 6 years. And now they changed it in the June 5th, they made the amendments. So now, the board, the motion is to support it, the bill.
Yes.
And just to hop on that, the board sponsored a bill a couple years ago with Assemblymember Eggman's office on exempt settings, and the request was because in our business and professions code at the time, we didn't have a limitation on the number of years someone could practice getting supervised professional experience in an exempt setting. So the bill changed it in our business and professions code, which was in line with welfare and institutions code, and health and safety code was also 5 years. No, there was one other code provision that was also 5 years.
It was the WIC. It's WIC and the business and professions.
Okay, so it was just those two, and then health and safety and penal code have been 3 years. So I think there's been some confusion on agencies that employ individuals that are getting supervised professional experience, how long they can function in that capacity without being licensed. So this bill was hoping to solve that discrepancy between the different code sections.
Yes. And it was kind of an inadvertent change. It really wasn't even, when we brought it up to the author's office, it was not, I don't think anybody had recognized that by striking that one part of existing language, you had extended us to 6 years. And so it was just a kind of a missed item, and we brought it up, and it's been resolved, and therefore we'd like to move to the support, so.
So there's a motion on the floor to, for the board to support AB 1456. Based upon this one.
Right.
Do you have any questions?
No, no questions.
So can you call for the vote,
Absolutely.
please?
Quabadu.
Yes.
Bernal.
Yes.
Erickson.
Yes.
Fu.
Aye.
Horn.
Aye.
Jones.
Aye.
Phillips.
Aye.
And that passes.
So the next item is SB 547, and this is one, and you might recall that when Ms. Burns was explaining the omnibus proposal process, she explained that SB 547 hadn't been introduced yet, so this is just for informational purposes, but again, those two changes about the fees, as well as,
Delinquency fee.
yes. Those are the two in the first item. So again, this is just for informational purposes. When there's a bill, we'll get this.
Can I ask a question?
Sure.
What does it mean, read first time and held at assembly desk?
That's at the main desk, so they'll read the bill out loud, and then so it gets to the assembly and they read the bill, this is a bill pertaining to da-da-da-da-da. It's read, so it now can be moved into the committees. So that has to be read by the assembly at the assembly floor, and then they'll send it to the rules committee, which will decide which policy and other committees it has to go to. It's just a procedural step along the way.
Okay, thank you.
Any other questions about SB 547 and more to come? And you think that the meeting would be, you said June 25th or June 26th?
June 26th.
June 26th.
Oh, and this one, although this one will be looking at a July hearing.
July hearing.
So before they go to, the legislature goes to recess in July, mid-July through mid-August, and then they'll come back into session. So they're going to try and get this heard before the July recess, so.
So let's move to thank you. Any other questions? So let's move to the next item. Is there any public comment about SB 547? Hearing now, we'll move to the 12B1C, SB 762. And Ms. Burns, if you could give an overview, this is about the renewal licensing fee for inactive.
Yes, so this bill would waive the renewal license fee for inactive licensees under all allied health boards, of which ours is one, for the sole purpose of providing voluntary unpaid service to a public agency, not-for-profit agency, institution, or corporation that provides medical services to indigent patients in medically underserved or critical need population areas of the state. Staff had concerns about this bill because it would essentially only solve one piece of a larger puzzle, and it's mandatory. So first off, it's a mandatory provision that we have to allow this. And second off, the medical board already has this provision, but they have 3 separate codes that incorporate a whole voluntary licensee program essentially. This one would only allow you to go from inactive to a voluntary. You couldn't just stay that way, so you'd have to renew inactive and then go voluntary, and then after that, there's no provision to keep it going. So there's some technical concerns that staff has with this bill and how it would operate, and then also the question of whether or not our board thinks this is a viable program for its licensees. Because it's mandatory, this would require us to start offering it in its current form without taking the consideration of the board looking at, does this work for our licensees? Do you want a continuing education requirement involved? How often could you swap back and forth between a voluntary license and an active license? Different considerations that the board would want to take if starting a new licensee type, just like we're going to be taking a look at retiree license types. These are the considerations the board would want to have before just saying, Board of Psychology, you have to offer this new license, and there's the technical concerns about it doesn't cover all bases for us as well. We did have discussions with the author, and so we're not quite certain that the author is committed to following these provisions through the process, but we will continue to watch it. But as it stands, as the legislation is written now, we would like to take an oppose unless amended position so that it was give us the authority to do this, but not mandate it, and then also work with the author on some cleanup.
And I just will add, this was discussed at the Policy and Advocacy Committee, and the committee has made that recommendation to the full board to take an oppose unless amended position. Dr. Horn.
So I have a question. I mean, I have concerns about this, certainly as written, so I agree with the oppose unless amended. I'm unclear about the amendments we want. I mean, one, it's not to be mandatory, but beyond that, is there anything else? We get to decide then what we want to do, or if we want to do it at all, and all that kind of stuff?
I think we would want to ask for broad authority to do this, and then to decide the determining factors at a later point, and also to remove where it's at in the statute is only regarding inactive licensees for renewal. So there's just some problems of where it's put and how it's worded. So we would call those technical considerations. And then also give us the authority, but make it a broad authority, not this specific one in the renewal section of code.
So if we move ahead with something like this, well, let's say, I mean, basically just asking that it be voluntary versus mandatory gives us then the latitude, is partly what I'm asking, to design or fashion a program, if we so choose, in the way that we want.
Exactly.
Okay.
So if they want to pursue it, we'd like a separate provision that's not in this code section that gives us the authority to pursue a voluntary license and to promulgate regulations to that effect.
Okay. If we decide to do that.
Exactly.
Okay.
Which would be an item of licensing.
Yes.
Right.
I mean,
No, you're right.
because I think that's
You're
the
right,
whole
you're
idea,
right, yeah.
really to have I mean, that was our discussion in Policy and Advocacy, a more full discussion we need to have.
Right.
Another option is just to ask for and oppose just to have it removed and keep it as physician and surgeon. That's another option if the board would just like to make that kind of black and white recommendation. If you feel like this is an appropriate license status that you would like to proceed with in the future, we could always seek legislation in the future. And that way we can have a real open and transparent process with stakeholders, get the statutory authority, and then promulgate regulations like we did with our retired status. So that's another option, is just to oppose and ask to be removed from the bill. So that it would not say healing arts licensee, but that it would just be kept as physician and surgeon.
Well, that would, I mean, I don't know. What do y'all think about that? I didn't even know we could do that, so.
I think it'd be
Would
an
that make sense?
elegant solution.
Huh?
It's an elegant solution.
Take us out.
I mean, I think that. Can I give you just a pause really quick? I'm getting an update live via text message. That the author is no longer pursuing. We have just gotten word.
Oh, okay.
So just kidding.
Never mind.
Right? The author will not be pursuing. So I guess at any later date and time, we can always have a discussion of our own and look at whether or not we want to start offering a voluntary license, which is something the Med Board currently has authority to do.
Well, the webcast works. The webcast works.
They are watching. They are watching.
So,
Thank you, Jason, by the way.
thank you, Mr. Glass-Steagall. So basically, then, there's no action needed at this time for this one. And I guess the comment, I think, given the conversation, would be that could be kicked over as a future agenda item for licensing at some point, maybe. I know lots of other things are on the plate right now, but that could be for later. Is there any other comment or public comment about SB 762, which we now know is not being pursued? Okay, I don't do a lot of things well, but I can definitely read body language, so we're going to skip a chunk so we can have our lunch break. Let's go down to the 12B3 section, the watch bills. We're going to deal with the number 2, the review of bills with active positions. That's an update on things we've already taken position. We'll calendar that for tomorrow. Dr. Phillips is telling me, so we'll do that. But the watch bills, and you might remember for the watch bill section, we're not going to go through each and every one of them. So if you have questions about any of them, let us know. But we do know we have 2 that we want to discuss and bring to your attention. One is a hand carry, and that is, so we'll jump there first, and then we'll open it up if there's other questions. Is that okay? So let's go to XX, excuse me. That's SB 715. I'm sorry. 55. XX on the agenda says that, but okay, that's not the right.
It's also a hand carry in your packet.
It's a hand carry, so it's the wrong number. I'm sorry. I'm sorry, XX, I was reading the wrong line. SB 755, civil discovery. Ms. Burns.
So existing law provides that any party may obtain discovery by means of a physical or mental examination of a party to the action, an agent of any party, a neutral person in the custody or under the legal control of a party in any action in which the mental or physical condition of that party or other person is in controversy in the action. This bill in particular would limit the mental examination of children that are less than 15 years of age where there's credible evidence of being sexually abused to psychological testing of no more than 3 hours, including breaks, unless the court grants an extension for good cause. This bill would also require the examination be conducted by a licensed psychotherapist, and that's defined as in Evidence Code 1010. That's also provided for you in your packet. So at the May Policy and Advocacy Committee meeting, there were public comments that expressed the removal of licensee discretion to determine the appropriateness of the time and amount of psychological testing was problematic, and the committee asked that staff reach out to an expert for a professional opinion on the 3-hour limitation and whether it was significantly outside of the current standards of practice for how long this type of testing should be done during these types of mental evaluations. We also asked if the court burden would be significantly high and problematic as well. We did receive input that's provided for you. It's in the memo that does talk about it is currently outside of the standard of practice to have this sort of limitation, and that limiting psychological evaluation to a time frame and then necessitating a judge's authorization for additional hours would result in delays between testing sessions and would unnecessarily re-expose the client to their trauma history. Such standards could have the potential to cause significant harm to a client and jeopardize the accuracy of the results, all of which is unnecessary. The expert also noticed there is the complaint process if they thought that this psychologist performing the evaluation was egregious in the number of hours and amount of testing being done on the child. An additional concern that was brought to staff's attention is that the bill specifies the mental evaluation must be conducted by a licensed psychotherapist in Evidence Code 1010. That includes licensed clinical social workers, marriage and family therapists, and licensed professional clinical counselors. And it was brought up that that may also pose scope of practice and competency concerns of allowing those providers to do these types of evaluations, whether or not that was intended by how they put it in the bill or not. That seems to be the impression. And then, so that for those reasons alone, we wanted to bring you the analysis provided by the Senate and Assembly Judiciary on the floor, and then also open it up for discussion. This is a somewhat narrower area, so for getting input and expertise is helpful. Staff's understanding of the bill and what it intended and means has changed over time, so we wanted to open it up for discussion.
So I actually do have a question, and I think this is more towards the psychologist. Isn't this pretty much kind of like a first step of what the other group was talking about? That, that there's children's protection and, whatnot?
It depends on the way you look at it. From what I understand from the response we got back from people that are in the assessment community, they felt that actually, if you had to do 3 hours and then go get the court to give you opportunity to do more than 3 hours, which truthfully probably would be more than 3 hours in any event, particularly if you're taking breaks with kids and, you want to give them some space to just wiggle around, that actually it might re-traumatize the kids because they have to come back and then go through an examination process again some months later. My bigger concern with the bill was that it's validating non-doctoral level practitioners doing testing in a setting which is not for diagnosis or treatment, but is actually for assessment for expert witness work, which to my understanding is outside the scope of license and outside the scope of competency for master's level clinicians. They can do some testing, but it's for limited purposes. But to me, it's a consumer protection issue because it's a question of how much training someone's had to do this kind of testing. Psychologists have an enormous amount of training typically to go into this area, whereas an LPCC, I don't think really has little or no training in the area of testing. And certainly, it would have a hard time finding supervised professional experience doing testing. So I think unintentionally, the scope of the statute kind of creates an impression that testing is now a kind of more wide open thing. So that was partly my concern because I don't think there's a lot of professionals that are competent to do testing.
I agree with your 2 points, staff's 2 concerns. I don't think that a child would be re-traumatized because I think psychologists who work in this area are trained to most kids, I used to test kids in these kinds of situations, and they loved the whole testing situation. And, you give them breaks, you do kinds of things with them, and I think psychologists are trained in that. And I don't think I think that is an artificial limit and does require completely unnecessary things. So I totally agree with that first point. It's the psychologist, with the expert's point, again, I don't think the child will be re-traumatized, but I think there are plenty of reasons not to. It usurps the profession of the psychologist's clinical, I'll say, judgment, and also usurps the ability to say that this kind of assessment is needed. And often when you get into an assessment, you might think you're starting in one place, and you do start in that place, but as you get into it, you find out other things that you really want to assess. So I just to say that. So, and then the part 2, I totally agree with Dr. Phillips there. This is something that psychologists clearly have training in. That's sort of our hallmark of, beginning to be applied psychologists was in assessment that's what we did. That's, kind of what makes us different. We have definitely received the training in that, and I'm not sure that other groups have received the kind of training that psychologists receive. So I'm totally support those two reasons. So.
Question to ask as a psychologist. Could this, kind of getting back to your question, Mrs. Spurnhill, could this testing, how could this testing, or could this service the evaluation process that was being talked about in terms of child custody and child abuse and sexual child abuse, how could that, or could this assessment, or these assessments be of value in any, or are they two different things, or how?
In my mind, I don't see that the two are directly related to each other.
But they're not.
I don't think they are. Certainly, there could be people that would be abusive, psychologists would be, but I don't even think they're claiming psychologist abuse. They're claiming that the psychologists are improperly designating one parent as the appropriate parent when that's not reflecting the data.
No, that I know, but I'm saying, could the information from this be in some kind of way? Could that impact have anything to do with child custody, what we heard this morning earlier? That's.
So in this way,
could
if a psychologist is, I'm sorry, I cut you
No,
off.
that's okay. Or could someone take this information and make the case one, let me say it that way, and make the case one way or the other?
So I'm not sure what you're asking, but I'll
No, let me
attempt.
say it again.
Well, let me attempt to
Okay, go
answer, and
ahead.
you tell me if I
Okay,
got you
all
right.
All right.
I think in a child custody evaluation, or any kind of evaluation that a psychologist does, there's always a possibility that the psychologist will use psychological testing as part of their evaluation.
Yes.
Always. But that wasn't the kind of complaint, those weren't the kinds of complaints or concerns that I heard the people talking about. It was, in fact, the recommendation that the psychologist was making. And I don't think this touches that. That would be my,
And you don't think it could be kind of information could be culled from that to make any kind of statement about evaluation, or custody evaluation? No?
Well, psychologists are always doing that. You're taking your evaluation and you are making your recommendations. But I don't think this speaks to that at all, yeah. It's just limiting the expertise, really, of the psychologist.
Isn't the author's intent here to try to limit the duress that a child will undergo by, say, 3 hours? We think that's not appropriate. Secondly, here's the professionals that can do it. We think that's limiting. So is there anything else the bill is promoting? It seems to me.
And Mr. Fu wants to get into here too, so when you're finished, Mr. Fu's next.
And I would just point out, it's definitely still talking about in civil discovery cases, so it's in a certain type of case. So we're not talking child custody, but this is civil cases. And in some of the Senate analysis, Assembly analysis, it'll talk about those kind of cases where it's a civil lawsuit brought against a YMCA for a parent, by the parents of a 3-year-old child that was molested by the summer camp employee. So these are civil cases. These are separate. So they're not the criminal case against the abuser. This is the civil case in this one. So this is.
Yeah, that's a good point.
Yeah, it's very
So
specific.
Here's another reason
Dr.
it
Hahn,
doesn't.
1 second. Mr.
Oh, I'm
Fu.
sorry.
Thank you. I was just going to bring that point up, which is the origination of why the consumer attorneys are sponsoring this bill, is that it was the lawsuit in that particular case, and to Dr. Phillips' point, it was a YMCA mental examiner that was conducting the testing. So as a part of that, so that's according to the analysis. So I think putting that into context to this conversation of why the author's proposing to it is, it does appear that the potentially the person conducting this exam was not, doing this test was not necessarily a psychologist. So I think that's something to think about as well, given the context of the bill's origination.
I'm not even sure that it's intentional when they've broadened the scope out to licensed psychotherapists and referred to the evidence code, which gives a broad definition of what a licensed psychotherapist is. The original law that is being changed, as I understand it, involved psychiatrists and licensed psychologists. And it was a civil discovery statute about psychologists and licensed psychologists and psychiatrists. And I think they've unintentionally maybe broadened it beyond the scope of what they wanted to do, and they probably aren't aware of the areas of expertise in the respective mental health professions. So maybe a question of educating, too.
And initiating those conversations with the author on this bill. So that's kind of where we would like to start and go from there.
So is everyone comfortable with that, or are we feeling that we need to take a position at this point in time?
Do you need a motion to initiate the conversation?
I don't for
It's a
the
watch.
conversation. I would if you wanted to take a position now. Since it was a watch bill this entire time, staff hasn't done an analysis. We haven't engaged the author. We haven't done any of that. But when the concern was brought up at the May Policy and Advocacy Committee meeting, and we talked to the expert, now it brings about concerns that we would like to talk about. So we can delve into it further. We can keep going. Of course, the bill process keeps going. It's obviously moving pretty quickly along. So it just depends on which way you'd like to go.
If it's moving pretty quickly, I would want us to weigh in other than just watch, because I think there's potential danger here.
So is that a
but-
motion, Dr. Horn?
Yes, but I don't know what I would want the weigh-in to be. Specific, oppose unless amended? I'm not even sure about the amendments, but, yeah. Huh?
Oh, I was going to say,
Would
that
that be
that
the
would be my
appropriate-
question on that one.
Really quick, just keeping in mind the legislative calendar, the last day for policies committees to meet and report bills is July, and we have a proposed teleconference in August. So if you guys wanted to take action, I would recommend taking a
Doing it
position now, if you'd like some particular amendments made to the bill.
Would you like to go with an oppose unless amended, based on the two concerns of the expansion of the types of providers and the artificial limitation of 3 hours, and delegate to staff to initiate those conversations for specifics? Would that work?
Yeah, that sounds good. I mean, I appreciate hearing this initial concern. It wasn't even about a psychologist. And yet, here we are potentially being included in this, and we are the experts, so
For clarification, this is going by the Assembly Judicial Analysis. It's at YMCA Mental Examiner. It's unclear from the analysis if this mental
whether
examiner
that
is a
was
licensed psychologist or not.
psychologist or not.
And I think, just for me, I need to know more about the bill. And I hear the concern about moving, I mean, the bill was heard 2 days ago already, so it is moving quickly, but
And it's only going through judiciary, so
it's not double referred, and so
that's why it's going so fast.
I would be curious actually to know more, and we're able to engage this conversation without taking a position on the bill. Is that correct?
No, absolutely.
I think that will prevent us from taking a position because we won't be
In
meeting
time.
again till August.
You would need to call a special meeting to take that position. That's the hard part with legislative deadlines in our meeting schedule is, and that's why we wanted to pull this up, and that's why it's also a hand carry, is when we've gotten the input we did, we now have significant concerns.
Although we do have the legislative committee delegation, so if the board felt a certain way about those two policy issues, let's say, and delegated to the chair of the licensing, or the Policy and Advocacy Committee, the president of the board, and then myself to work on any kind of amendments if need be. We have that delegation authority in our Administrative Procedures Manual,
so.
Could you state the motion?
She didn't make a motion.
Well, no, but she was formulating a motion. I mean, she's not going to make a motion, but.
Oh, you're talking about Ms. Sword. I thought you were
Ms. Sword,
going to.
yes.
Maybe an oppose unless amended position to address the issue of the expansion with the evidence code and the limitation on the 3 hours, and then delegate to the Policy and Advocacy Committee Chair and Board President any additional changes throughout the process before the board meets in August. Because even if Policy and Advocacy, I mean, even if the policy committees met and the changes weren't made, we can still be advocating for the bill if it gets to the governor's office. So, I mean, it would be a support or veto message versus an amendment advocacy letter, but, I mean, we would still be able to be a part of the process.
I guess my question is, if you're going to oppose unless amended, except with respect to those issues, kind of what's left of the bill?
Right.
There's,
That's my concern, too.
there doesn't seem to be, I mean, the bill seems to be directly.
Or that we just oppose the bill because of those two issues.
That's where I was gonna, that's the hard part of this one.
That feels even.
It seems like if they would amend to just psychology and psychiatry and remove the hour limit, we could probably support that.
It's still crafted the way that somehow, it's hard to imagine how that would look like, because I think it really does cut the.
It does, because I think the consumer attorneys would like some sort of limitation on these long evaluations that they consider to be abusive and excessive. So, and we haven't talked to the sponsors of this bill yet either, so I mean, this might be a broader conversation to have with them. I'm sure there are others, I believe, in opposition. No? On file?
You know what? Ms. Marks just brought up a great idea. We could find out some information today, and we can bring this back to the board for discussion tomorrow.
I think that's actually an excellent idea, and that would give people a little bit more time to review the hand carry anyway. And I just want to point out, because I feel like Mr. Glassspiegel and Ms. Burns and Mr. Connor are doing a great job by giving us all these watch bills, but know that all the watch bills have not gotten a deep dive. And so that's also which is why I think Ms. Burns was starting off by saying, we can initiate some conversations, because they haven't initiated conversations with all of these ZZs and AAs, and so there's a lot of bills here that we're watching. So I think that might be the better way, that we hold off till tomorrow, and everyone can take a look at this evening, and we can have a more thoughtful conversation about it.
Good.
But I just feel like, for the sake of, we'll talk about it again, but is there any public comment about that? She did never make a motion. Did you make a motion? Did anyone second it?
No.
There's no motion.
There's no motion.
So, the public comment, please. Thank you.
Just be careful.
I appreciate it.
Joe Linder Crowe, CPA. Never have I wished that my lobbyist was sitting beside me more than at this very moment. But I do have, you know.
The webcast works for you, too.
Yes, it does. One note is that this bill is not, so the definition of a licensed psychotherapist is in the evidence code. So this bill is not suggesting a change in the evidence code. The bill is to amend the civil code with no change in the definition of what a licensed psychotherapist is. So if you go down that trail, that would be a huge, whole different thing. You would be suggesting that you don't like the evidence code and you don't like the definition of a licensed psychotherapist. So the bill is intended, as we understand it, to just address this issue of the limitation on the hours of an evaluation. We worked with the author's office very hard to get that last little phrase in, unless the court decides otherwise. So with that addition of that, because we were concerned about the fact that sometimes 3 hours is not enough. So what do you do then? So with that addition of that language, we moved to a neutral position on the bill, just FYI. It's our understanding that, just like on Wednesday, no, today's, whatever day it was, Tuesday. And as we understand, there's no other opposition to this bill. So just, if that helps to clarify it all.
Did you get the impression from speaking to the author's office that they intended to broaden the scope of who the evaluator should be? I almost feel like I'm not advocating when I say the definition of a licensed psychotherapist. What I'm saying is,
No.
it might not be a great idea for them to incorporate that in this statute.
It's our understanding that the bill says psychologists and physicians.
The original bill said that, but my impression was, and I'll have to go back and reread it, that by incorporating licensed psychotherapists, they were by implication saying that these people were, it was within the scope of their license to be able to do these assessments and to do this testing. And that goes to scope of practice, but more importantly, from a point of view of the board, it goes to a competency issue in terms of whether these are people that are competent to be doing assessment of children.
Right,
whether
and
they're
it previously
really
also referred to expertise in trauma. So I would say that if we can provide any, if you're going to set this back just a little bit to gain more information, then I will be happy to get some more information if that could be helpful. But my understanding is that they actually intended to narrow the people that would do the evaluations, not expand it.
So actually, I think we already said that we as a board would come pick it back up tomorrow. So it sounds like we have a couple more questions to look at. Mr. Glassbeagle is watching, so I'm sure he's writing that down as well.
Right, and Ms. Levy is watching, so.
Hi, Ms. Levy.
Hi,
So
Amanda.
we get a chance to be able to look at that, but if you have another question, Dr. Erickson, we can throw it out, because maybe that'll help inform our conversation for tomorrow.
My hunch, and it's only a hunch, is that the author wanted to narrow who could do this to licensed psychotherapist, which we don't think is narrow enough. Further, my hunch is that the person who did this exam in the YMCA was probably not licensed. Why would they make a point of saying a licensed psychotherapist otherwise?
And I think the statute originally, the statute has existed, I think, already in the code. I think they're amending a code section. Said psychiatrist,
Civil
licensed
code.
psychologist, yeah.
Civil code,
Right.
right.
So it's a psychiatrist and licensed psychologist.
Yes.
Then they, later on, add in this definition of licensed psychotherapist, which may not really be
I see what, yes, I
comport with
see
their
what you mean.
intentions.
It does look,
It's
yes.
kind of a mixed,
I read it that way as well, and that's why I was
so
asking,
maybe it could
what does this?
be clarified pretty easly. I
Yeah,
don't know.
yeah.
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 Thank you, Ms. Levy. Thank you, Mr. Glassbeagle. Any information you can text Ms. Burns or Dr. Linda Crow. We appreciate that. So I will turn it back over to you, and we will pick back up policy and advocacy tomorrow.
Okay, we're going to defer the rest of the Policy and Advocacy Committee agenda till tomorrow. We will be coming back at 2:20, since you're either going for fast food somewhere in the neighborhood, or you got the restaurant here. I think those are your choices. So why don't we convene back here at 2:20? That'll give us some time to go through some additional agenda items that we've deferred because of the order we took things this morning. And then at 3 o'clock, we will be going, we'll be having a petition for reinstatement hearing, or petition for termination probation. So we will see you all at 2:20. Thank you.